supplementary list of final item 1, WPL 5248 of 2009.
Will the notice to be done?
Let it be remanded.
What do you say?
It is covered by your lordship's judgment.
There is a that one is that the tribunal holds that these things have not been taken into consideration or whatever.
But the factum which otherwise not to be considered, that is a quasi criminal proceeding, and whether the default was purposeful.
We will say that that you have relied upon these judgments, and I have not held in this judgment that they do not have any discretion. I have only held that the discretion became curtailed after the
32A, yes. And it is
32A
more like, and it is
introduction.
reasonable when he applies the formula of 32A. paragraph
32A, I
That
have
you
held
also
that
held
also.
specifically.
Yes. Here in this particular case, what has happened is that they actually did not produce their records before the authority, and ultimately this order was passed, and which went in appeal, and this appellate court has passed this order.
And appeal
Then under such circumstances, I think you produce the records, and then he will pass the order in terms of he has got no business to overrule the judgments passed by.
he cannot.
He cannot do
He is
it.
bound
He has
by-
to follow
He is
it.
bound by this.
So he will pass the judgments in accordance with law, taking into consideration the judgments which you have cited and their records. And I would also like to say that it is also equally important as to when did they pay the wages and what were the deductions made. These are the things which are required to be taken into consideration. As I was telling yesterday, if you pay the wages and deduct the amount, you have no business to retain it.
When under the IPC, my lord, there is a illustration given that when PF amount is deducted and not remitted, that will amount to criminal breach. That is a specific statutory illustration.
Okay. So therefore, if you deduct it and don't pay, it becomes all the more serious.
Yes.
Okay, so these are the things which you will have to produce, but it will be absolutely for you to produce the documents to their satisfaction. This opportunity we will give.
Madam, he will not take time.
No, we will give a time bound.
I will not produce
No,
it.
there is no scope. If you say it is old document, that same order will be repeated. Old document का कहानी मत सुनाइएगा.
नहीं.
Period कब से कब तक?
96 से 2007 का.
96 से 2007 का और 7 का है और वहाँ कभी नहीं बोले हैं कि मेरे पास रिकॉर्ड नहीं.
लिटिगेशन कंटिन्यू कर रहा है.
लिटिगेशन कंटिन्यू कर रहा है.
इनफैक्ट हम जो बोले हैं वहाँ पे कि आई विल प्रोड्यूस द रिकॉर्ड.
यस. उसके बाद लास्ट में आपको टाइम नहीं दिया, उसके बाद फिर मैटर क्लोज हो गया. सो यू ऑलवेज वांटेड टू प्रोड्यूस द रिकॉर्ड्स. सो देयर इज नो स्कोप फॉर यू टू से दैट यू डोंट हैव द. इफ यू डोंट हैव द रिकॉर्ड्स, गाज आप ही के ऊपर गिरने वाला है. ठीक है. देखिए WPL नंबर 5248 of 2009. This petition has been filed for the following reason. The learned counsel for the petitioner has submitted that the impugn order passed by the learned tribunal is perverse. He has submitted that a plea was taken by the establishment that they had huge financial crunch, which resulted in delay of remittance of PF dues. Such plea is not available as an excuse for non-remittance of PF dues. He submits that the learned tribunal has taken into consideration the judgment passed by Honorable Kerala High Court in the case of Indian Telephone Industries Limited versus APFC and others, reported in 2006 within bracket 3 bracket close KLJ 698. And a few judgments. But the said judgment of Honorable Kerala High Court was subject matter of challenge before the Honorable Division Bench of Kerala High Court, and the judgment was set aside. This aspect of the matter has been taken into consideration by this court in WPL number 6155 of 2010, pronounced on 23rd of September 2024. The Learned Counsel has also submitted that the Learned Tribunal, after recording that the order impugned, that the order passed by the Assistant Provident Fund Commissioner contained no elaboration of the manner in which the damages have been computed. And that the authority had misapplied himself in holding that he had no power to reduce or condone the damages imposed under section 14 capital B. And having found various fault in the matter of quantification of damages, and that by quantifying the damages, the authority had not followed the law laid down by the Apex Court and the High Court. Instead of remanding the matter back to the concerned authority for quantification of damages in accordance with law, abruptly reduce the damages to the extent of 5% by simply referring to inverted comma ends of justice without any further discussion as to how the ends of justice would be met if the damages are reduced to the extent of 5%. The Learned Counsel has also submitted that in spite of repeated opportunities, the establishment did not produce the records before the Assistant Provident Fund Commissioner, and under such circumstances, the order passed by the Assistant Provident Fund Commissioner did not call for any interference. He has also submitted that a mere statement of huge financial crunch made by the establishment without producing any documents and other evidences as to how and in what manner the salary was to be paid, when it was paid, how the deductions were made from the with respect to the employee's contribution. The mere statement is not sufficient to waive any portion of the liability under section 14 capital B. Over and above this aspect, he has submitted that the law has been declared by the Honorable Supreme Court that financial crunch is not a ground to avoid liability under section 14 capital B of the Employees Protection Act. He submits that the manner in which the impugned order has been passed, the manner in which the damages has been reduced to 5% calls for interference, and accordingly the impugned order passed by the learned tribunal be set aside. The learned counsel has relied upon the following judgments. You want every judgments to be mentioned in the order?
As you know,
आप बताइए कौन कौन सा मेंशन करना है, हमको क्या है, हमारे तो स्टेनोग्राफर टाइप कर देंगे आप जो जो बोलेंगे। ये सब जो आप यहाँ पे लिखे हैं यही सब लिख देते हैं, ठीक है? ये एक एक पॉइंट पर ना जो जो है साइटेशन सब निकाल।
एक सबमिशन क्वाशी क्रिमिनल होल्ड किया ट्राइब्यूनल, दैट इज नॉट द करेक्ट, योर लॉर्डशिप हैव आल्सो हेल्ड इट प्रोसीडिंग क्वाशी क्रिमिनल नहीं है।
The learned counsel has also submitted that कहाँ होल्ड किया क्वाशी?
ट्राइब्यूनल है Para 5, page 55. After relying the Hindustan Steel versus Odisha Journal. Under section 14, we also para 5. When
The learned
considered
counsel has also submitted that the finding of the learned tribunal in paragraph 5, that imposition of damages under section 14 capital B of the aforesaid act is quasi-criminal proceedings is also contrary to the view expressed by the Honorable Supreme Court. The learned counsel appearing on behalf of the establishment submits that the establishment is essentially a government of India undertaking.
Yes.
Is essentially a government of India undertaking which has its branches all over the country.
All over the country.
All over the country. He has further submitted that the
So it is an NGO, my lord, they say in contrary.
Under Registration Act, sorry. Under Society Registration Act, it is an NGO.
Page 2, para 5.
the learned counsel for the establishment has submitted that the establishment is a non-government organization having its branches for the purposes of manufacture of khadi clothes. Khadi बनाते हैं ना? Khadi clothes, and has been receiving fund from Government of India from time to time.
Yes, sir.
And a stand was taken that they were suffering huge financial crunches which resulted in delay in remittance of PFGs. However, during the course of argument, it is not in dispute that the establishment did not produce the records before the authority, in spite of having granted repeated opportunities. At this, the learned counsel for the establishment has submitted that one opportunity may be given to the establishment to produce the records which may be verified by the concerned authority, who may pass fresh order in line with the various judgments which has been passed by the Honorable Supreme Court, and also the order passed by this court in WPL number 6155 of 2010. The Learned Counsel has also submitted that. In the judgment passed in WPL number 6155 of 2010, this court has held that the discretion to impose maximum damages up to quantum of default, this court has held that the discretion has been curtailed after 1988 with regard to quantum of damages, but still the discretion is there, and mind is required to be applied with respect to the number of defaults, the period of delay, the frequency of this default, and the amount involved. ये चार term है by this. After hearing the Learned Counsel appearing on behalf of the parties and considering the facts and circumstances of this case, this court finds that in spite of repeated opportunities which was granted to the establishment to produce the records, for one or the other reasons the records could not be produced. However, it was never the case of the respondent of the establishment before the authority that they are not in possession of the records. It appears that the Assistant Provident Fund Commissioner has assessed the damages up to the maximum possible, up to the maximum limit, by simply stating that financial difficulty faced by the establishment is not a valid ground for committing default. This court finds that the establishment had approached the tribunal and had taken a plea that the establishment suffered huge financial crunches which resulted in delay in remittance of Provident Fund dues. The appellate tribunal has recorded in various paragraphs that the authority is not required, is not entitled to, that the calculation under section 14 capital B is not mechanical application of formula, but it requires application of mind in various aspects of the matter. So far as imposition under section 7 capital Q is concerned, no interference was there. Q 7Q follows 14B.
Yes, interest, it is interest.
It's 7Q follows. This court finds that the appellate tribunal had also referred to the judgment, aforesaid judgment passed by the Honorable Kerala High Court, but it was not brought to the notice of the appellate tribunal that the said judgment was set aside by the division bench and one challenge. This court also finds that the learned appellate court recorded that the impugned judgment passed by Assistant Provident Fund Commissioner suffered from various legal infirmities in connection with non-application of mind with respect to various factors, but instead of remanding the matter to the authority for fresh consideration, the learned tribunal, after having held that the order impugn suffered from legal infirmities, they restricted the damages only to the extent of 5% per annum on the arrears of contribution by referring to ends of justice. This court is of the view that the tribunal, having found that the authority had not applied its mind in the matter of quantification of damages, ought to have remitted the matter to the authority for fresh consideration. This court also finds that in the judgment passed by the Honorable Supreme Court, reported in bracket 2001, bracket close 4 SCC 449, the Honorable Supreme Court, having found errors in the matter of quantification, was of the view that the matter was fit to be remanded, but on account of long delay, the Honorable Supreme Court exercised its power and limited the damages to the extent of 25% of the total damages imposed. This reference to Tribunal. This court is of the considered view that the learned tribunal has also erred in law by observing that the imposition of damages under section 14 capital B of the Act is quasi-criminal proceedings in paragraph 5 of the impugned order. In the judgment passed by the Honorable Supreme Court, in the case reported in paragraph 20, reported in bracket 2022, bracket close 4 SCC 516, the Honorable Supreme Court has observed that in proceedings under section 14 capital B, there is no requirement of examination of element of actus reus / mens rea, or to examine issue of justification for imposition of damages. The Honorable Supreme Court has also held in the judgment. कौन सा जिसने बोला civil liability?
And this horticulture only, madam.
अच्छा.
Paragraph
In
15.
the aforesaid judgment itself, as held in paragraph 15,
15, 18 and 19.
15, 18 and 19, that the liability under section 14 capital B is essentially a civil liability. this court in the judgment reported in the judgment passed in WPL number 6155 of 2010 has held in paragraph 29 से ले लेना
28
अच्छा 28 to 31 as answer 32 31 as answer. This court is of the view that one opportunity is required to be granted to the establishment to produce the records so that the damages in terms of section 14 capital B and consequently interest in terms of 7Q be quantified in accordance with law, keeping in mind the principles laid down by the Honorable Supreme Court in the matter of calculating damages under section 14 capital B and also the judgments which has been relied upon by the petitioner. When will you produce the records? अंश आपको 2 महीना दे पुराना रिकॉर्ड है खोज के समेट के अच्छे से प्रोड्यूस करें. Essential facts would be कब आपका I'm just indicating we do not want more litigation on this.
Yes.
Essential facts would be कि आप जो सैलरी देते हैं कहाँ से आता है आपके पास सैलरी? क्या गवर्नमेंट के एड से आप सैलरी देते हैं? I don't think ऐसा होता होगा, but still we do not know. Right? Salary तो you generate. You have to generate the salary of the employees. दूसरा चीज़ employees को कब salary दिए, कब deduction किए भी कि नहीं किए भी क्या किए, deduction नहीं करना भी एक default है. और कब आप जमा किए, इसका month wise detail देंगे क्योंकि सारा calculation month wise होगा. दिसंबर में default हुआ है तो अगर जनवरी मार्च तक कैलकुलेट करेंगे तो 3 ही महीना का डिफ़ॉल्ट होगा. जनवरी में डिफ़ॉल्ट हुआ है तो आपका 1 साल का या जितना भी होगा डिफ़ॉल्ट वाइज आप स्टेटमेंट बनाकर अपना रिकॉर्ड प्रोड्यूस करेंगे तो फर्दर आपको लिटिगेशन नहीं करना. द मैटर इज रेमिटेड टू द अथॉरिटी टू द कंसर्न अथॉरिटी नेमली Regional Provident Fund Commissioner जमशेदपुर. कौन करेंगे ये ऑर्डर इनका? वो जिसको भी देंगे
अभी असिस्टेंट नहीं करते हैं
रीजनल. I will just remand it to regional provident. The matter is remitted back to the Regional Provident Fund Commissioner who shall do the needful in accordance with law, either himself or appoint an appropriate authority in terms of the delegation of power as may be applicable for passing a fresh order in connection with the quantification of damages under 14B and interest under 7Q for the period involved in the present case, that is from 4/1996 to 2/2007. Without being influenced by the ये ऑर्डर तो ऑलरेडी सेट असाइड है.
हाँ, ट्राइब्यूनल हैज सेट असाइड द ऑर्डर.
ट्राइब्यूनल हैज सेट असाइड द ऑर्डर.
Only the tribunal order is to be set aside.
Yes, the order passed by the इसको थोड़ा ठीक से कर देंगे हम. The impugned order passed by the tribunal is set aside. The order which was impugned before the learned tribunal is also set aside, so that fresh order will pass in accordance with law. The petitioner, the establishment shall produce the records and also give the details in a tabulated chart. आप अपना चार्ट भी बना लीजिए with regard to the period of delay, etc. On 9th December. On 9th of December at 11 a.m. The establishment is directed to cooperate with the proceedings and final order be passed by 31st of January 2024 and be communicated to the establishment after giving an appointment to That's it. ये बहुत ग्रे एरिया है 14B का कैलकुलेशन कैसे करना है आप लोग कभी भी आप लोग कैलकुलेट नहीं ऑर्डर along with the calculation sheet. You also file your own calculation sheet.
Yes,
What's the big deal about it?
But I have two cases, my lord, in which PF has subsequently accepted his miscalculation, my lord.
We have seen एक और केस में हम भी सेटिस्फाइड किए एक्सेप्ट कर लिए तो बड़ी बात है ना अपनी गलती एक्सेप्ट करने से बड़ा क्या हो सकता है This is the highest thing a person can do.
Yes, ma'am.
गलती एक्सेप्ट करना You should appreciate it.
From daily list, item 31, contempt civil 427 of 2023.
On the last occasion, it was disclosed that they have referred an LPA, which is pending.
LP has been allowed.
No, Your Lordship, we are filing an affidavit in the matter, Your Lordship. The matter is covered from one LPA which is already decided by the Honorable Division Bench, Your Lordship. So I am praying for only 1 week
No,
time,
you have preferred your independent LP.
Lordship.
So you get it decided. Yeah, so defective छोड़ दिए.
Not only the division bench, but up to SLP, the order has been confirmed, but even then, if they are seeking time, I have no objection, let them issue the rent receipt, mutate my name, that's all.
क्या आपका कहानी में समझ आ रहा है आपको ये बोलते हैं LPA किया आप बोलते हैं SLP तक डिसाइड हो गया
नहीं नहीं
Out of the same khata, lands in question, other lands in question decided up to the SLP. That was that
आप
has been.
देखिए मैडम इसमें एक रीट में ऑर्डर हुआ है आपको रीट के ऑर्डर को सेटिसाइड कराना पड़ेगा दूसरा ऑर्डर से आप इसको कंटेम्प्ट नहीं ड्रॉप
ये ऑलरेडी फाइल किया है, Your Lordship. उसमें बस
डिफेक्टिव है
लिमिटेशन का डिफेक्ट बचा हुआ है, Your Lordship.
कब रख दे बताइए
इसको ऑप्टिफिकेशन
LPA नंबर बताइए नंबर नहीं पढ़ा है क्या
नंबर पड़ा
732.
732 of
those are things.
23.
Contempt civil 727 of counsel for the parties are present. Counsel for the state has submitted that against the order passed by this court. LPA number 732 of 2023 has been filed, and a limitation petition is yet to be filed in the same LPA. She submits that appropriate steps will be taken for expeditious disposal of the LPA. बताइए at her request, the matter is directed to be posted on 6th of December.
Lordship.
On 6th of December 20.
Item 32, contempt civil 534 of 2023.
Yes.
This is also the state has prepared an LPA that is pending in the Lavazima police.
LPA number
LPA number 623 of 23.
6.
623 of 23.
Effective.
If the state has filed the LPA, the Wal Cooperative Bank has filed a civil review.
Sorry.
There is two type of parties are here.
Yes.
Plus in various paragraphs, Lords has held that they are not the employee of the bank. They are the most employee of the estate. In the Lords paragraph 20, Lordship has recorded that they were working in bank. And as such, Lords has directed the bank will pay and then they will recover from the estate. We wrote them Lord's estate.
Okay, anyways, we are not bothered at what we have already held. You just tell us what are the proceedings which are
Penalty is with respect to the other rate. No rate.
अच्छा छोड़ दीजिए
There
कोई
are few
बात
rates
नहीं।
where
आपने क्या रिव्यू भी फाइल किया है?
एक रिव्यू मेरा पेंडिंग है 51/23।
तो इसको क्यों नहीं प्रेस कर रहे हैं?
ये लोग एलपीए फाइल कर दिए थे स्टेट, जब इनसे पैसा इन्हीं से लेना है, ये लोग फाइल कर दिए एलपीए, तो हम इसको नहीं कर रहे थे कि एलपीए में क्या होता है, क्योंकि देयर ग्राउंड इज दैट दे आर नॉट द स्टेट वर्कर, वी कैन नॉट पे इट, दे आर द वर्कर ऑफ द डिस्ट्रिक्ट कैडर कोऑपरेटिव सोसाइटी, दिस पैक्स इंडिपेंडेंट बॉडी, they are best aimed to give the ex gratia. So substantial claim is not from the state, not from the bank. Bank is the only account holder.
ग्रांट इन एड थोड़ी उसके एम्प्लॉय बन जाएंगे स्टेट के।
Therefore, Milos, the whole crux is
ग्रांट इन एड बोलने से तो स्टेट के एम्प्लॉय थोड़ी बन जाएंगे, वो ग्रांट इन एड से पैसा मिल जाएगा तो मिल जाएगा।
हाँ वही ऑलरेडी है।
अच्छा ठीक है, चलिए कोई बात
पेज 41 ऑफ द
अभी कुछ नहीं। अब बताइए कौन सी तारीख को डालेंगे? ये तो लगता है अभी 1-2 साल डिसाइड नहीं हो पाएगा। इनका रिव्यू तो रीट से भी ज्यादा लंबा चलेगा।
हुजूर, ये सिर्फ हुजूर का जजमेंट और एक रिप्रेजेंटेशन है जो हमने स्टेट को दिया है।
देखिए, कंटेम्प्ट सिविल 534 of 2020, काउंसिल फॉर द पार्टीज आर प्रेजेंट। स्टेट कौन है? काउंसिल फॉर द पार्टीज आर प्रेजेंट। इट हैज बीन रिपोर्टेड दैट LPA number 623 of 23 has been filed by the state, which is pending. Defective. However, the LPA is still defective. The Learned Counsel for the state has submitted that they will take appropriate steps for expeditious disposal of the LPA. गलत submission लिखा है क्या? And the matter may be adjourned. Counsel for the JEPC has submitted that
Bank, Dhanbad Central Cooperative Bank.
Dhanbad Central Cooperative Bank has submitted that one civil review being 51, civil review number 51 of 2023 has been filed, but the pending LP of the state will have a direct bearing on the civil review petition. He submits that the civil review be taken up after disposal of the LP. Correct?
Milos,
Yes or no?
no, Milos. I am saying that
तो आप सिविल रिव्यू मेंशन किए हैं, पेंडिंग है, डिफेक्टिव है, क्या है?
नहीं, डिफेक्टिव है, ऑर्डर भी डिफेक्ट के हेडिंग में है।
Okay. But ऐसे लिखिए, civil review number 51 of 23, which is defective, he also submits that he shall take expeditious steps to remove the defect in the civil review. Oppose this case on 6th of December 2024, along with review तो यहीं पर आएगा, civil review number 51 of 2023.
Grateful, Milos.
On the next day, the State Council shall inform this court about the status of the LP. वो मंडल वाले केस से जो चलता था वही है ना सर?
हाँ हाँ, इसमें सिर्फ इतना ही है।
ये हमको नहीं सुनना है अभी, कंटेम्प्ट
ठीक,
हमको नहीं सुनना है इसमें क्या?
oblige, Milos.
Item 33, contempt civil 547 of 2023.
Yes, petitioner.
The leadership order has not been applied.
Complied or
क्या चीज छूट रहा है? कुछ भी नहीं किया है। ये बोलते कंप्लाई कर।
अप्लाई कर दिए हैं, उसको इन्फॉर्मेशन पिटिशनर को दे दिया गया है। 3 लाख का पेमेंट करना
तो
इंटरेस्ट
एफिडेविट तो यहाँ फाइल करना होगा ना? Should I say that you have complied the order? Compliance report क्या किया है कंप्लाई में?
अप्लाई में
चिट्ठी लिखे?
3 लाख के साथ इंटरेस्ट के साथ पेमेंट था, वो पेमेंट करके और चिट्ठी लिख दिए पिटिशनर, इन्फॉर्म कर दिया रजिस्टर।
यही ना आपको चाहिए, 3 लाख के साथ इंटरेस्ट के साथ पेमेंट। फिर
Can you
पूछ लीजिए
verify with the petitioner?
when
A week's time.
22/9/23 को ही हम इन्फॉर्म कर दिए पिटिशनर।
contempt civil 547 of 2023. Counsel for the parties are present. Counsel for the opposite party has submitted that the order of this court has already been complied and the amount of rupees 3 lakhs with interest has been remitted to the account of the petitioner. Counsel for the petitioner is directed to verify this fact and file an affidavit before this court. कहाँ का मैटर है?
साहब
तो कब रख दें बताइए?
नेक्स्ट वीक
Post this case on next Thursday. The affidavit उस दिन बता देंगे जो भी है. In supplementary list.
Item 34, contempt civil 594 of 2023.
Notice was issued by the opposite party also. That the petitioner was directed to the
Opposite party के counsel से को देख के हम समझ जाते हैं कि order comply हुआ है कि नहीं हुआ. Comply हो जाएगा तो उनका कोई junior counsel आके बोलेगा कि comply हो जाएगा. आप बताइए क्यों नहीं comply? What are you up to?
My humble submission also has been complied with. My lords, on the direction of the honorable court, that is the mixture one of page 41 of the contempt application.
What was the nature of direction?
Direction is to dispose the petition by demarcating the land. My lords may come
Has
to
been
the
demarcated?
prayer of the petition is at paragraph 2, my lords. The petition has been filed for the following issuance of a writ of mandamus commanding upon respondent number 4 to expedite and conclude the demarcation proceeding pending before him by demarcation case number so and so filed by the petition which is still pending without there being any justifiable reason.
That's right.
My lords, paragraph 4 is also important. My lords. Paragraph 4, counsel for the response submitted that although the notice for demarcation has been cancelled, but the demarcation case has not been closed. Then the counsel has also submitted the petition approaches the respondent court by filing a representation. Then fresh
That's right.
My
You
lords.
issued fresh notice.
My lords, thereafter, my lords, we have filed one modification application. My lords, state has filed a modification. In that, my lords have held that there is no ground for review or
That
modification.
I have rejected the review. I
My
remember.
lords.
Then
There we have filed a show cause, my lords, earlier by rejecting that, my lords. My lords, by the order dated 20th August 24, my lords are directed to find a compliance. Thereafter, we have filed on show cause, my lords. That is dated 17/10/2024.
it's a compliance report or show cause?
Show cause, my lords. My lords may
It
come.
means that you have not complied.
My lords, I have complied the order, my lord. You may have some objection.
Okay.
My lords may come to annex page 13 of the second show cause, my lords.
Page 13.
13 show cause filed on 17/10/24.
Yes.
Annex 13, my lords.
What is this? Map?
This is the map of the
Mausoleum.
Ashok Nagar Housing Society, my lords.
This is the Ashok Nagar Housing Society case.
My lords. This is
Then
here this mark is there. My lords. That mark, Part C.
community hall, part B, part C.
Part C. That is the land what
Which is-
my the petitioner is claiming. My lords may come to annexure B, my lords. Page 14, my lords.
Yes.
This is the land acquisition case of 2 of 1961-62. The housing board has acquired the land, my lords, and thereafter transferred the land to the Ashok Nagar Housing Society, my lords. My lords, thereafter come to page 15, my lords. Page 15. Serial 4, my lords. Chottu Mehto, Walad Kamal Mehto. Here the plots of what the petitioner is claiming, my lords. They are the plots, my lords. Thereafter may come to page 41, my lords. The ancestors of the petitioner has received, ancestors of the petitioner, the owners of that particular land have received the compensation, my lords. That is also serial number 4, my lords, page 41. Thereafter, my lord, we have issued the notices, my lords. Page 65, annexure D, my lords, 64 and 65, my lords. In view of the subsequent order of this honorable court, my lords. Page 66 is the report of the Amin, my lords.
Upon measurement?
My lords.
It's a report upon measurement.
Page 66, my lord. Here what the observation is, my lords. The plots against the देखो उनका पक्का मकान और रास्ता बना हुआ है और आगे लास्ट से सेकेंड लाइन में आवेदित पर पार्ट नहीं बना हुआ. Thereafter, we have passed a reasoned order, my lords.
आवेदित भूमि पर पार्ट नहीं बना हुआ.
My lords. That is the proposed. Earlier, what I have shown, that is the land, that is the proposal. उसकी जगह मैंने बहुत सारा घर बना हुआ, घर और रास्ता बना हुआ उस जमीन पर. Thereafter, my annexure of page 67, my lords, we have passed the reasoned order considering the Amin report, my lords, wherein finally we have concluded that considering all these, we have closed the demarcation case. My lords, may come to the one of the pleading of the petitioner, my lord, the reason for the demarcation case, my lords.
Measurement report is what?
My lords,
You see, when Amin would go on the spot, will he not demarcate the boundary? Has he done that?
my lords, demarcation of the boundaries has not been done, my lords.
That is
Only
what is
that has been
required.
identified, this is the
See,
land.
He has
Ma'am.
to go to the spot and say that this is plot number, it starts from here, it ends here,
Ma'am.
and it starts from here and it ends.
Well, that has been shown, my lords.
That has been shown in your map.
My lords.
No, you have to show it on the ground. The
Ma'am.
demarcation, you see, you have a map
My lords.
in which you have number of plots. But what is the demarcation on the spot?
Here the issue is, my lords, he is not having any title over that land.
You don't bother about the title. Nor we are going to decide this title.
Why we are concerned, my lords may see paragraph 7 of the writ petition, contempt application, the pleadings of 7 and 8, my lords. Paragraph 7 and 8. And even in the writ petition also, he has suppressed the facts, all these facts, and mentioned that he is in the position of the law. My lords, paragraph 7, my lords, we have placed that paragraph 7 at page 8, my lords. That the petitioner states and submit the petitioner wants to know the chavardi of the land which is his possession. Then approach before the private and requested him to demarcate the land bearing so and so and so, total area of 1.61 acres, but nearby Rayat holder who are the powerful man by wealth and political approach created disturbance to Amin and threatened to not to demarcate the land of the poor petitioner, and so many times the private
We are not concerned. You
My lords,
see,
one more, my lords, one more.
he may not be the owner of the land. Whatever it
His
is.
intention, paragraph 8 he has mentioned, that the petitioner states that the purpose of demarcation case land is only the petitioner want to know the chavardi of land and make a boundary wall on the land, so that in future he may save from every disturbance of elements in the locality of the area some people want to grab the land. Here his intention is to make the boundary, my lord, but the land has been acquired in 1962, my lord.
Whatever it is. You go on the spot, demarcate.
Once we went to the spot, my lord.
Did you demarcate?
We have shown the land, my lord. This is the land.
नहीं ये लोग कभी नहीं किया.
No.
4-2
It is not reflecting. You see, you have to go there, prepare a sketch map. These are the boundaries. That's all. You demarcate it on the spot. He is not going to get a title out of it.
Yes.
There is no
But
question of
but
getting a
after
title out of
demarcation, his
it.
intention is to make a boundary.
Whatever
wall.
his intention, do you think that his intention will survive in front of mighty state and that to Ashok Nagar society? You think he will succeed? You have to just go on the
No,
spot,
if he-
demarcate the boundary and stop.
No, humble submission. If he is having a title over the land without any dispute, then boundaries can be defined.
Then you should have challenged the order. We do not.
No, here, my lord, in accordance with the law.
In accordance with law, certainly in accordance with law. There is a.
Law suggests that if there is civil dispute, that has to be referred to the civil court and demarcation.
He is not raising any dispute. He only
No,
wants.
he is
You see,
raising
the
a dispute.
order, you forget about what he is. The order is that you need to demarcate. You simply go and demarcate. Whosoever is in possession of the property, you are not going to declare anybody's possession, nor you are going to declare anybody's title. You have to simply go on the spot, put खंबा क्या बोलते हैं उसको, ईटा डालते हैं या जो भी, बस उतना करके आप आ जाइए. इसके beyond कुछ नहीं. It will not confer title on anybody. There is no question of confirmation of any title. If the property is belonging to Ashok Nagar society or whosoever society, there is no question that he will. This will not give him a license to.
But it creates.
ऐसे नहीं चलेगा. आप order comply करिए. You go on the spot, demarcate and that's all.
अभी
इसमें सप्लीमेंट्री एफिडेविट फाइल करी, स्पॉट पे 4/9/24 को कभी लोग गए ही नहीं है। 4 लोग
नहीं उतना करने का
चार
जरूरी
लोग
गए ही नहीं है तो दिख ही रहा है।
फोटोग्राफ्स भी लगा दिए, 4-5 किलो गए, उसका
आप उसको वहाँ
रिप्रेजेंटेशन
जाइए, फोटोग्राफ ले लीजिए, ईंटा लगा दीजिए जहाँ आपको चौहद्दी में लगाना है, करके आएंगे, ऑर्डर कंप्लाई करके कब बताइए। नो सीक इंस्ट्रक्शंस, यू जस्ट टेल मी व्हेन विल यू गो, you give a date, I'll ask him to be there, you give a date, बाहर से पूछ के आइए कौन से तारीख को जाएंगे।
Item 35, contempt civil 682 of 2023.
Yes, petitioner. Order has been complied. इतने सारे लोगों का क्या मैटर है? Yes. What happened? What is the present status?
Responding number 4.
Not the last occasion was directed to, with respect to zone 1, this is about vendor marketing. With respect to zone 1, we also there was a direction to the deputy commissioner to
Seek
consult the application a lot of the municipal commissioner. And with respect to zone 2 and zone 3, we have the direction to seek to file an appropriate affidavit with respect to the current status. But with regard to the last order, the affidavit could not have been filed. But I have obtained the photographs, this photograph is of September 2024. But I could not file an affidavit.
Saying what does it mean?
But there is construction has above shade has not been constructed. Other than that, everything is complete. This is with respect to zone 2.
Zone 1?
Zone 1, there is a Dhana Bhagans, we have wrote a letter to the deputy commissioner to get the premises vacated, so appropriate action can be taken.
You are representing deputy commissioner. What is your stand?
Lordship, our instruction is we need to take time for 1 week to file an affidavit because of the code of conduct.
कब से कोड ऑफ कंडक्ट लग गया? जब से ये कंटेंट पेंडिंग है तब से चल रहा है क्या कोड ऑफ कंडक्ट आपका? 11/8/23
20/9 का ऑर्डर था ये लॉर्डशिप।
अब कोड ऑफ कंडक्ट का नाम मत लीजिए, ओके? कोड ऑफ कंडक्ट में लिखा हुआ है कि कोर्ट का ऑर्डर कंप्लाई नहीं करना है।
नो ये लॉर्डशिप।
इज देयर एनी सच कोड ऑफ कंडक्ट? यस देन इतना वीक डेप्यूटी कमिश्नर हम आज तक देखे नहीं हैं। बताइए डीजीपी को ऑर्डर करें, किसको ऑर्डर करें कि आपको पुलिस फोर्स प्रोवाइड करें? यस
इसमें हम इंस्ट्रक्शन ले लेते हैं आफ्टर
इंस्ट्रक्शन ले लेते हैं।
इसमें हम लोग एफिडेविट टू दैट एक्सटेंट हम लोग फाइल कर देते हैं लॉर्डशिप। इसको बस आफ्टर वेकेशन का कोई भी
कौन सा वेकेशन?
दिवाली वेकेशन।
कौन सा दिवाली? हमको तो लग रहा है अगले दिवाली तक भी ऑर्डर कंप्लाई होने का कोई चांस नहीं है। देखिए हम तो अभी यही है, मेरा तो ट्रांसफर अभी होने का कोई उम्मीद हमको नहीं लग रहा, और ये कंटेंट दूसरा कोर्ट में जाएगा नहीं। डोंट टेक दिस कोर्ट वेरी लाइटली, ओके? एक एक शब्द हमको याद रहता है जब तक केस पेंडिंग है। कोई एनक्रोचर आके वहाँ पे घुस जाएगा, यू विल नॉट टेक एनी स्टेप्स, कुछ नहीं करेंगे आप। जिसको मन होगा जहाँ जाके बैठ जाएगा। परमिसिव पोजीशन कल को एडवर्स पोजीशन के लिए तो अलॉट कर देंगे उनको आप। और जिनका घर सही सलामत बाउंड्री के अंदर है उसका तोड़ते रहिए नोटिस दे देकर। और ये क्यों नहीं इसका शेड कंप्लीट हो रहा? पैसा खत्म हो गया है? पैसा है ना, खत्म हो गया। देखिए अभी दिवाली का टाइम था, शेड वेड बन जाता, अच्छा एक मार्केट होता, लोग शॉपिंग कर रहे हैं, इस सब चीज़ का कोई सोच ही नहीं।
के प्रपोजल की जस्ट मेरी बात हुई मैं म्यूनसिपल कमिश्नर का एक पर्सनल अपीयरेंस था मेरा, तो मैंने अभी बात रखा वहाँ पर कि ऐसा सब क्यों है। तो उन्होंने प्रपोजल दिया कि एक जो मार्केट अभी बन रहा है इसमें स्पेस काफ़ी ज़्यादा है, तो हम लोग सभी जितने भी वेंडर है सभी को एक ही जगह ऑक्यूपाई भी कर सकते हैं, बाकी जगह अबंडन कर देंगे तो भी एक प्रपोजल ये भी एक है, जितने भी ऑक्यूपेंट हैं उनको आप एक ही जगह
कितने लोग हैं इसमें इन्वॉल्व, कितने लोगों की रोजी रोटी इसमें इन्वॉल्व?
अभी तो सभी लोग अपने अपने जगह पर कर ही रहे हैं।
कर ही रहे हैं मतलब क्या?
करीब जो लास्ट 2016 में सर्वे हुआ था उसके हिसाब से बहुत
यहाँ पे लोगों को चेम्बर नहीं मिला तो इतना हंगामा हुआ, यहाँ पे इन लोगों को दुकान नहीं मिल रहा, आपको कोई मतलब नहीं।
नहीं मिनट
आप समझ रहे हैं ना बात?
हाँ मिनट दुकान तो बंद है।
आप लोग को चेम्बर नहीं मिला तो इतना हंगामा हुआ कि इसको नहीं मिला, इसको मिला, उसको नहीं मिलना चाहिए, इसको मिलना चाहिए, सब हुआ ना। तो इनके बारे में सोचिए, हाउ मेनी पर्सन्स आर देयर? 202 पर्सन्स। बहुत से लोग तो थोड़ा एडवांस एज में भी हैं।
और इसमें से जो है वो लोग जो सर्वे वाले लिस्ट में हैं भी नहीं, फिर भी वो तो अलॉटमेंट वाले की चीज़ बाद में, पहले कंस्ट्रक्शन तो हो जाए उसके बाद की बात है, तो प्रोसेस में हम अलॉट हो जाएगा सर।
कितना टाइम आपको चाहिए कंप्लीट करके लाने के, कंप्लीट करके अलॉटमेंट करके आने के? कितना टाइम आपको चाहिए ये बताइए।
और एक जो लास्ट ऑर्डर है मतलब उसका कंप्लायंस एक बार हम कर देते हैं, उसमें मतलब लास्ट ऑर्डर था कि जो जोन 2 में जो बन रहा था क्या स्टेज ऑफ कंस्ट्रक्शन है,
कोई बात
वो
नहीं,
एफिडेविट
स्टेज ऑफ
कंप्लीट
कंस्ट्रक्शन आपका ये फोटो में आ गया ना?
हाँ तो मैंने
दिख
थोड़ा
रहा
सा
है।
समय इसमें लगे, मैंने उसको इंस्ट्रक्शन खाली एक एफिडेविट हम वो फाइल कर देंगे।
वो तो आप एफिडेविट फाइल कर देंगे, पूरा इसका शेड बना के अलॉटमेंट करके सब कुछ करके आने में आपको कितना टाइम लगेगा? जो चीज़ है उसको तो नहीं बर्बाद करिए ना।
नहीं तो है।
हाँ, उसमें कितना टाइम लगेगा बताइए? एट द अर्लीस्ट तो आज कल तो हम नहीं देखें, आप देखें
नेक्स्ट वीक
नेक्स्ट वीक हो जाएगा आपका? The learned counsel for the parties are present. The learned counsel appearing on behalf of Ranchi Municipality. Ranchi Municipal Corporation has submitted that though no affidavit has been filed, but photocopy of certain photographs have been produced to show that the marketing complex in zone 2, the construction of marketing complex in zone 2 is in progress, and as per the photograph, the frame for the shed is standing on the spot. He submits that on the matter be adjourned to the next week, and he shall inform this court on affidavit as to how much time will it take for Ranchi Municipal Corporation to complete the construction of the shed and allocation of the shop in the shed. With respect to zone 1, he submits that letter has been written to the Deputy Commissioner to provide police assistance, but no response has been received. The learned counsel for the state has prayed for time and has submitted that on account of model code of conduct, the Deputy Commissioner Ranchi needs more time. However, she is not in a position to satisfy this court that imposition of model code of conduct is a ground not to comply with the order passed by this court, and the matter is pending before this court since 11/8/2023, alleging non-compliance of the order dated 1/5/2023. However, she also placed for adjournment to file an affidavit in the matter. कब का फाइल करेंगे? Next week. लिखिएगा मॉडल कोड ऑफ कंडक्ट से orders are kept in abeyance by default. You write it on affidavit. We will consider it. That by default, the orders will be kept in abeyance. Okay. Post this case on next Friday. ये रख लेते हैं इसमें.
I will bring more record of the I will affidavit. Lord, your worship, keep it in the record.
So,
Your worship can keep it in the record. I will bring out an affidavit.
देखिए अगर कोई रिट का ऑर्डर इफ यू आर नॉट केपेबल ऑफ कंप्लाइंग you can file a petition saying that you are not capable of complying. Therefore, it is an order which cannot be executed. You can file a review petition. We'll see. Let the deputy commissioner say that he is not capable of removing illegal persons on the spot. We will record it, don't worry. But for that you will have to file a review petition. Contempt में नहीं बोल पाइए. Review file करिए. That the order should be recalled because deputy commissioner is incapable of complying the orders of this court. Maybe various reasons. There could be many. Or you challenge it before the division.
Item 36, contempt civil 7450/2023.
The last order, they say that the rule has
Rules
been
are-
framed. No, it is a resolution, and it is a
Sankal.
simple. Sankal means intention to frame a rule, whether it has been notified or not. Let them say if it has notified, then it is it will be. I will get the benefit out of it.
No, this is final. Municipal के आदेश.
Notification.
With respect to visit notification, I have to seek the instruction. It has been notified.
Until it is notified, I cannot take any benefit out of it. It say कि it has to be notified, and I have an instruction that as on date also it has not been notified.
देखिए तो फॉरवर्ड किया गया है.
तो notified नहीं
हाँ तो
होगा.
नोटिफाइड होगा.
कब लॉर्डशिप में सी कब का ऑर्डर है ये?
कब का है?
11/6/24. 11/6/24 ये राज्यपाल के आदेश
Council for the
अनुसार.
parties are present. The council for the opposite party state has submitted that by virtue of resolution number 2101 dated 11/6/2024, the rules have been framed. Council for the petitioner has submitted that the rules are of no use as the same has not yet been notified in the official
As it is a
gazette.
resolution which says the dictionary meaning intention to frame rule.
He submits that unless it is notified, the same is a scrap of paper and cannot be implemented. Council for the opposite party is directed to seek the aforesaid resolution revealed that a copy of the same was forwarded for publication in the official gazette. Council for the state is directed to seek instructions and produce a copy of the
Gazette notification.
post on 14th of November in the supplementary list.
Item 37, contempt civil 821 of 2023.
Neither complied nor.
Not complied.
Nor complied.
So, AGC is not supposed to comply orders. You are for the state. Where is HGC? Ronak Shahai is not appearing. On the last date, I remember that after the order, I was informed that he is not well. Something has happened to him.
He had made an accident.
He has made an
That is
accident.
why one junior had appeared.
Yes.
And Lordship had.
So he has recovered.
I don't know.
On 28-24, the matter was adjourned to 18th of October 24. कोई बात नहीं, नोटिस एक्सेप्ट किए थे ना, आप उनको नोटिस कर देना, ठीक है? कौन है? सीएमडी को किए हैं पार्टी?
CMD.
रिस्पॉन्डेंट नंबर कौन है? रिस्पॉन्ड नंबर 1. Contempt civil number 821 of 2020. Counsel for the petitioner and the counsel for the state are present. On 27 to 24, Mr. Ronak Sahai, advocate, had appeared and accepted notice on behalf of opposite party number 1. And he was granted 4 weeks time to file his show cause. The matter was then taken up on 28-24, and by that time also the show cause was not filed. And on that day he was not appearing. The matter was adjourned to 18th of October 24, and today also nobody is appearing on behalf of opposite party number 2, nor any prayer has been made for adjournment. In such circumstances, let notice be issued to the opposite party number 1, opposite party number 1 through the concerned police station for which requisites be filed by the petitioner by Monday. The learned counsel for the state is directed to seek instruction and file affidavit of the officer in charge of the concerned police station after service of notice upon opposite party number 1. The affidavit of service be filed by November 11th, post on 14th of November in the supplementary business.
Item 38, contempt civil 1066 of 2023.
Yes.
Payment can be done.
Complied? Contempt civil 1066 of 2023. Counsel for the petitioner submits that the order passed by this court has been complied. Considering the submissions,
We have also filed an affidavit.
though belatedly, थोड़ा late हुआ, though belatedly, considering the submissions, this court is not inclined to proceed further in this contempt petition, which is accordingly stopped. अपना appearance.
Item 39, criminal appeal essay 36 of 2024.
Yes, petitioner. Counsel for the petitioner is absent. Close this case on. Counsel for the appellant is absent. Close this case on. Twenty-fifth of March.
Number 30.
Yes.
Can be Monday, Manoj. Maybe deleted.
Monday?
Yes.
Then in the file. Contempt civil 594 of counsel for the parties are present. Counsel for the opposite party has submitted that the petitioner does not have a right direct interest over the property involved in the present case, and an appropriate affidavit to that effect has been filed. Counsel for the petitioner has submitted that in terms of order passed by this court, the demarcation on the spot has not been done. The petitioner is not asking the respondents to declare their right title interest and possession of the property, but the order passed by this court is required to be complied with in the circle of who will go?
Circle officer.
The circle officer is only required to demarcate. He submits that. At this, the counsel for the opposite party has submitted that the petitioner be directed to be present on the spot on Monday at
4 p.m.
at 4 p.m. and the necessary demarcation will be done in presence of the petitioner. He has submitted that it may be made clear that demarcation will not confer any right title interest or possession upon the petitioner. Correct? Considering the aforesaid submission, the petitioner shall appear on the spot at 4 p.m. and in presence of the petitioner let the demarcation be done. There can be no doubt that demarcation by itself will not create any right, title, interest or possession in favor of one or the other person. The demarcation report be filed before this court by Thursday, or maybe later, by 11th November, by 11th November, post on 14th of November to the second.
Item 40, contempt civil 274 of 2024.
Yes.
Your Ladyship, an LPA has been conferred and it was taken up on 3rd October. The next date fixed is on 21st November 2024. So any date which the court may fix in the matter.
Okay, you have filed the
Yes, yes.
this lady. Yes. Interesting. Notice issue. You have accepted notice. You are
Yes,
appealing.
they had filed a caveat, your lordship, they have appeared, yes. Next date is 21st November 2024.
So when do we post it?
After 21st of November. LPA number 160 of 2024.
160 of
2024.
Learned counsel for the parties are present. Counsel for the parties submit that LPA number 160 of 2024 has been filed against the judgment passed by this court on the judgment passed by this court in WPS number 6207 of 2017. They submit that next date fixed in the NPA is 21st of November, and the matter is posted thereafter. Post this case on 6th of December. The supplementary cases.
Item 41, contempt civil 295 of 2024.
The order has not been converted. It has filed.
कंटेंट इतना होता कैसे होता?
Direction was to
16
consider
petitioner
each
हैं
case of
और
each
सारा का रिप्रेजेंटेशन इंडिविजुअल देना था सेपरेट और दैट इज एन एंड हियर
क्या वेल्की कर दिया?
has filed no एलपी नहीं फाइल हुआ है. इसमें क्या हुआ है कि एसएलपी पे ये एक रिट फाइल हुआ है जिसमें हम पार्टी नहीं हैं. आफ्टर द ऑर्डर ऑफ दिस ऑनरेबल कोर्ट वन रिट हैज बीन फाइल्ड बाय अनदर 13 पर्सन. In that case they have taken a stay order from the court और उसमें हम पार्टी में thereafter state has directed to file affidavit और affidavit भी फाइल किया गया है counterfeit. thereafter petitioner has directed to file rejoinder. आज तक rejoinder भी फाइल नहीं हुआ और अब ये plea ले रहे हैं कि उस केस में स्टे है इसलिए हम नहीं देंगे, जबकि सारा का एडमिटेड फैक्ट है. ये एडमिट भी किया कि दे हैव ऑल पिटिशनर्स हैव their own parcha. He has state has to give the possession, your Lordship. But due to this case, your Lordship, they are not doing.
For the same piece of land edition, so an encroachment case was initiated edition, and in that case, against that notice edition, a writ petition was preferred, and a stay has been obtained in that writ petition. So implementation of this order could not be done due to stay edition. A detailed show cause has been filed edition.
Total land is 2 acre 37 decimal. इन्हीं का हम आर्गुमेंट में सॉल्व. टोटल लैंड 2 acre 37 decimal. जो encroacher who has been served notice, they have filed writ petition, have all in total 13.
Is it overlapping? Are the properties involved in this case overlapping? Where have you said so in the court?
For sedition, we have used an issue of A edition.
And who are those persons?
डिटेल नहीं दिए हुए हैं.
इसमें edition के out of 2.37 acres of land, that is a page.
Out of 273, ऐसा नहीं. I just want to know that whether the land involved, land of these, whatever be the claim, is overlapping with the land involved in the same case. Show me that statement.
Out of 237 acres leadership, it has been stated that 61. Page 32 leadership. For the concerned piece of land, it has been stated that कुछ व्यक्तियों को विस्तार योजना के तहत पूर्व में भूमि बंदोबस्त की गई थी, जिसमें कुछ बंदोबस्तधारी का बंदोबस्त भूमि पर दखल कब्जा है तथा कुछ भूमि आम रास्ता एवं नाला के रूप में तथा शेष भूमि पर अन्य व्यक्तियों द्वारा अनाधिकृत रूप से मकान बनाकर अवैध दखल कब्जा किया गया है. वर्तमान में आवंटित भूमि खाली नहीं है.
This particular land, the land involved in the present case is not vacant.
No leadership.
Wrongly submitted. My lord, they have, state has issued notices to all 13 persons, your lordship, in which measuring land has been incorporated. Kindly have a look at this petition. Writ petition हम पूरा notice ही लगा दिए. और उसका डिटेल शोकॉज में नहीं दिए. इवन he has issued the notice. सारा नोटिस हम लगाए, वही है, रीट का कॉपी है. उस रीट को इसके साथ टैग कर दिया जाए.
ये रीट तो मेरे पास नहीं होगा.
नहीं होगा, वो तो नहीं आता.
कैसे?
मैं सब्जेक्ट मैटर क्योंकि ली इस रीट में इवन योर लॉर्डशिप ऑर्डर हैज नॉट बीन प्रोड्यूस्ड बिफोर दैट कोर्ट. योर लॉर्डशिप मिसलीड करके ये ऑर्डर ले लिया. और 13% इवन मान लो 13% को भी अगर ये इंक्रोच कर लिया तो 13 का 13 into 3 तो 39 डेसिमल होता है. मेरा 16 पिटिशनर है योर लॉर्डशिप रिट में और कंटेम्प्ट अभी 12% आए हैं तो 48% इसमें होता है
that the your land whatever you are claiming is demarcated.
yes
You
not
show me
demarcated now demarcated by the in this so called they have given कि हाँ आपका पर्चा है कुछ लोगों का 4 लोगों का डिमार्केटेड कब्जा में है अब ये क्या सोकोज फाइल के जिसमें मेरा पोजीशन भी है उसको भी कहते हैं कि इनक्रोचर में है आप इस 12 में से 4 लोगों का वहाँ है
read your shows. Place it.
From page 10 leadership, it would be relevant that pursuant to the order, out of 16 petitioners, 14 have filed their representation in light of the order. And after this revision, a detailed...
2 persons have not filed their representation.
No, two filed. And then a separate miscellaneous record was opened with respect to all the 14 petitioners leadership.
Paragraph 17 is irrelevant.
Page 12.
आप पूरा पढ़िए ना text. Out of 16, 14 have filed.
14 have filed their representation before the opposite party number 2. As regards petitioner number 2, Gutka Ravidas and petitioner number 5, Loki Ravidas of WPC students are concerned. They did not file any representation before the answering opposite party number 2 till today. Hence, no action with regard to petitioner number 4 and 5 would be taken. That it is humbly stated and submitted that as regards other petitioners of this contempt petition is concerned, it is submitted that after receipt of representation from the petitioners, the in charge circle inspector and revenue deputy inspector were directed to inquire into the matter and submit detailed report. It is further submitted that separate miscellaneous records for all the 14 petitioners bearing no swings or number were opened. Then, after receipt of inquiry reports from the in charge circle inspector and revenue deputy inspector Mahagama, the records were put up on 1923 after perusal of inquiry reports of all the 14 petitioners were noticed to appear before the answering opposite party number 2 and they appeared on different dates with a prayer to provide them land for construction of houses under rehabilitation scheme and issue settlement purcha in their respective names as they are landless and poor persons and belong to backward and scheduled caste category. Then it is humbly stated and submitted that from the inquiry report it further appears that 2.37 acres of land of plot number 1, Khata number 22 of Moja Marito, Khana number 691 of Mahagama Anchal has been acquired by the government under Land Acquisition Act 1894 and handed over to the Rajmahal Project Eastern Coalfield Limited for development of coalfield and the same land area of land that is 2.37 acres of plot number 1 and 2 of Moja Basua so-and-so Mahagama Anchal has been handed over to the district administration by the Rajmahal Project Eastern Coalfield Limited for resettlement and rehabilitation of the landless persons. That it is important to mention here that by reference number so-and-so, the area manager Rajmahal Group of Mines Gonda Dharmakia informed the Deputy Commissioner Gonda that the aforesaid lands were returned to the district authority by letter number 460 dated so-and-so for distribution among the landless persons. That it is only stated and submitted that the lands in questions were enclosed by 37 persons as per list annexed and for their eviction from the said lands necessary action is being taken by the encroachment of case number 5 of 2324. That during the pendency of encroachment case, some of the encroachers preferred WPC number 6417 of 23 before this Honorable Court and the Honorable Court after hearing the parties was pleased to stay the execution and implementation of the notices till further order. Hence, awaiting further order of this Honorable Court, no action for rehabilitation of the petitions of this case will be further taken. Then, with regard to petitioner number 8 is concerned, leadership, she died leaving behind only one of her dependent only filed a representation without obtaining any no objection. So, case
वही नंबर जाएगा ना 2-3 जनरेशन. Let 2-3 generations finish. Then what? Don't you feel ashamed when you say that the petitioner has died without getting the fruits of an order of this court? And then you object. Legal hair file दिया है succession certificate नहीं.
और even after the stay order, how his claim has been rejected? ये तो ये और भी contempt है. Second case का भी ये contempt हो जाएगा. If he has एक का कर रहे हैं दूसरा का नहीं कर रहे हैं. पैराग्राफ 18 देखा जाएगा.
आपको जो प्लॉट है आपको कोई एरिया अर्मार्क हुआ है उसका बाउंड्री है।
नहीं हुआ है ना, यही तो इंक्वायरी रिपोर्ट है एनेक्चर ए से देखा जाए। सारा को बोल रहे हैं कि आपको पहले वाला का हुआ था, वो पर्चा जो मिला 3 डेसिमल का वो सब है, उसके जगह पे बसुआ में मिला, बसुआ वाले पे नहीं हुआ है, क्योंकि वो 45 लोगों का ऑर्डर शीट में आया है, उसमें 45 लोग को और को दिया गया था पहले, जिसका कोई आज तक रिकॉर्ड नहीं लाए हैं।
16 रेडिशन earlier, इसमें से 14
अभी नए वाले में
13
अगर मान लीजिए 13 को आप एलोकेट करेंगे तो पूरा लैंड खत्म हो जाएगा।
नहीं 39 डिसमिल होगा एज पर, अगर उनको पर्चा मिला होता
तो फिर बाकी का क्या करना है?
इवन रेडिशन क्लियर नहीं है क्योंकि 2.37
वो क्लियर तो आपको करना है ना। इतना वेग चीज फाइल कर दीजिए कि कोर्ट को कुछ समझ नहीं आया, उसके बाद कोर्ट, हम तो ऐसे हैं नहीं ना, आपको जब समझ में नहीं आएगा तो हम इसी यहीं पर अटक रहे, अगला केस कॉल आउट ही नहीं होगा।
वैसे भी हुजूर अगर 45% को कंसीडर किया जाए हुजूर, हम
यहाँ से भेज देते हैं किसी को एडवोकेट कमिश्नर को, वहाँ पे अपॉइंट करें, आप ही चले जाइए।
ये अच्छा करा देंगे।
ऐसा तो नहीं है ना that the entire land has exhausted।
नहीं अभी
उनका जो भी है, either they are in possession, उनका पोर्शन छोड़कर बाकी पोर्शन में आप अलॉटमेंट कर दीजिए।
This aspect has to clarify, be clarified.
What clarified? This aspect has to be carried out, not clarified।
और स्टेट
आपके घर में अगर एक किसी कोना में कुछ डिस्प्यूट हो जाए तो पूरा घर डिस्प्यूटेड हो जाता है क्या?
और इवन यू लॉर्डशिप
एक इंडल्जेंस लीडरशिप 2 वीक्स के बाद इसको लिस्ट कर दिया जाए, इस पे क्लैरिटी
कंटेम्प्ट में ही
आपका स्माइल बता रहा है कि आपको पता था कि ये गड़बड़ है।
अरे ऐसे भी स्टेज ऑफ पिटीशन है, that has to be considered your lordship as per article 226 your lordship।
सुनिए उनको दिवाली गिफ्ट दे कर आइए, दिवाली अपने घर में मनाएंगे, अपने जमीन पर, अगला हफ्ता देकर आइए। कुछ ये सब फालतू बातें सुनते। These are all lame excuses for who has filed this affidavit? Circle officer। सर्कल ऑफिसर के पास घर है? कितना
वो पता
कहाँ के सर्कल ऑफिसर?
महागामा
कहाँ है महागामा?
गुड्डा में।
घर तो पक्का होगा। लिखिए कंटेम्प्ट केस सिविल नंबर 295 of 2024। The learned counsel for the parties are present। The learned counsel for the state has submitted that the circle officer has filed a show cause in this case and has submitted that pursuant to the representation filed by only 14 petitioners, only 14 writ petitioners, different cases have been opened, which has been numbered as 1 of 2324 to 14 of 2324. She submits that 13 persons have filed another writ petition,
WPS 6417,
being WPS number 6417 of 2023, 2023, when steps were taken against them for removal of encroachment. And therefore, there is a technical problem in compliance of the order passed by this court. Counsel for the petitioner, while opposing the prayer, has submitted that the land has not yet been demarcated for the 14 petitioners. And even if the land under encroachment of 13 petitioners who are in WPC number 6417 of 2023 is kept aside, there is enough availability of land with the respondent to comply with the order passed by this court. He submits that pendency of another case filed by 13 persons cannot be a ground for non-compliance of the order passed by this court. If there is an order of stay for removal of encroachment in their cases, the same will have no bearing in the present. Counsel for the state is directed to seek instructions and file a supplementary affidavit in this case by next Thursday, the petitioner shall approach the circle officer Mahagama on Monday at 11 a.m. so that the order of this court is complied.
खाली 14% का पिटिशनर लिखा है क्योंकि रीट में 16 था, दो छूट जाएगा अगर नहीं फाइल के
14% है ना,
नहीं पिटिशनर टोटल 16 है,
इसमें कितना
कंटेम्प्ट में 14 है,
हाँ तो कंटेम्प्ट
लेकिन ऑर्डर कंप्लाई तो रीट का होगा, अगर
नहीं हमको जो नहीं आया उससे क्या लेना देना,
मतलब ऑर्डर तो रीट का है,
उससे कोई मतलब नहीं है, जो नहीं आया उसका 14 petitioners who are there in this contempt proceedings,
फिर रीट वाला ऑर्डर
उससे कोई मतलब नहीं है, तो जो नहीं आया उसको कैसे रिलीज मिलेगा,
किसी कारणवश नहीं भी आ सकता,
कोई बात नहीं, जब आएंगे तो उनको भी नहीं मिलेगा।
लैंड लूजर है,
आप जाइए ना, आप जाइए उनका भी कल्याण, वो लोग क्यों नहीं आए, क्या बात है, चाहते हैं नहीं चाहते, मेरा सो नहीं, ठीक है 11 बजे,
हाँ ठीक,
हाँ पोल नेक्स्ट फ्राइडे, नेक्स्ट 28 को रख देते, पोस्ट ऑन 29th इन सप्लीमेंट्री कॉलेज, दिवाली के पहले कंप्लायंस, मैडम हैव सम मर्सी ऑन देम, झारखंड में भी नहीं आप देखेंगे तो कौन सा स्टेट में देखेंगे, इसीलिए इतना रिसेंटमेंट होने लगता है, जो उनका देने का है उसको दे के निपटिए ना, उसके लिए भी सोचते रहते हैं कि आएंगे देखेंगे मिलेंगे,
13% इंक्रोच भी कर लिया है तो उस मच लैंड स्टिल वैकेंट,
कोई बात नहीं चाहिए और चाहिए।
Item 42, contempt civil 345 of 2024.
Suppose has been filed, but order has not been complied.
Why the order has not been complied?
As per the
Page 10 में kindly visit.
रुकिए ना, अब हम तो उनसे पूछ रहे हैं तो आप क्यों परेशान हैं, मैं बताइए।
Because the order, the direction of this honorable court was to look into the grievance of the petitioner and if required, then demarcation of that concerned plot was to be done. We have done the demarcation and a reasoned order has also been passed. But his claim was that construction is being made on a public road. So as per the counter affidavit and the show cause and the reasoned order, the construction is not going on the public road. It is the land which is Gair Majurwa arm in nature, and its nature is Kabristan, over which the construction is going. So we have complied.
Page 22 of so called में kindly visit.
पहले हम ऑर्डर देखते हैं, क्या डायरेक्शन,
Page 10 is the order.
पेज नंबर,
Page number 10.
व्हाट वाज द डायरेक्शन, सीधे डायरेक्शन है,
This petition is disposed of, enabling the petitioner to file a press representation along with his record and a copy of this order for resolution
ठीक है
of the
देखिए,
grievance.
रिप्रेजेंटेशन फाइल किया आप,
हाँ किए.
उसके बाद
Upon filing of such representation, the respondent number 2 shall look into the grievance of the petitioner and take appropriate steps in accordance with law, and if required, he may also ask for on-the-spot inspection and measurement through the circle officer with the help of government appeal.
मेजरमेंट हुआ,
हाँ वही पेज 22 में kindly visit. Page 22 also. Six का second paragraph, thereafter 6 का खाता नंबर 100 and 100 अनाबाद साधारण किस्म रास्ता की भूमि पर मौजा चौड़ी, ये विलेज का नाम है, में आने जाने का मुख्य पक्की सड़क अवस्थित है। thereafter ख में भी लास्ट 4th लाइन पढ़ दे रहे हैं, किंतु उक्त भूमि का पश्चिम भाग में अर्ध निर्मित चहार दीवारी खाता नंबर 336 प्लॉट नंबर 265 सड़क के भूभाग में अवस्थित है। उक्त अतिक्रमित भूभाग की लंबाई उत्तर से दक्षिण की ओर 205 कड़ी एवं औसत चौड़ाई 10 कड़ी है। इसके बाद पेज 28 में काइंडली विजिट व्हाट द डिप्टी कमिश्नर हैज डन। पेज 28 मिडिल पैराग्राफ सबसे लास्ट लाइन, कोई भी अतिक्रमण नहीं है। बेस्ड अपॉन दिस रिपोर्ट
इसी अब अतिक्रमण है कि नहीं है, आप
नहीं यही तो रिपोर्ट में आ गया है, अतिक्रमण है और डिप्टी कमिश्नर ने कह दिया कि अतिक्रमण नहीं है, अभी तो अतिक्रमण है, दिखाए। ये अतिक्रमण कितना है? 205 कड़ी और औसत चढ़ाई 10 कड़ी, इतना बड़ा अतिक्रमण है। और पब्लिक रोड है ऊपर, हम इसीलिए पढ़े कि ओनली वन रोड इज देयर who is connecting the village. मेन
कौन अतिक्रमण किया?
कब्रिस्तान। और इसी में और ऑर्डर पास क्या कर दिया कि याचिका का भी पढ़ दे रहे हैं इम्पोर्टेंट। अतः याचिकाकर्ता का आवेदन स्वीकृत करते हुए जिला कल्याण पदाधिकारी पलामू को निर्देश दिया जाता है कि कब्रिस्तान की भूमि की 4 दीवारी का निर्माण कार्य पूर्ण कराना सुनिश्चित करें। अब जो अतिक्रमण है उसको भी ये कंप्लीट मतलब कंस्ट्रक्शन कर देंगे इस ऑर्डर से। ये
अतिक्रमण को पुख्ता कर देना चाहते हैं।
पुख्ता कर
रीजन ऑर्डर में तो है कि इट इज नॉट इन अतिक्रमण।
कहाँ है इट इज नॉट इन?
इसमें यहाँ पे ये फाइनल लास्ट पैराग्राफ में तो लिखते हैं कि याचिकाकर्ता के आवेदन एवं अंचल अधिकारी हैदरनगर द्वारा समर्पित भौतिक निरीक्षण सह सीमांकन प्रतिवेदन के अवलोकन से स्पष्ट होता है कि गत सर्वे खाता संख्या सचिन सच प्लॉट
देखिए आपका ये जो आप लिखे है ना, हमको ये समझ नहीं आ रहा।
हम रीजन ऑर्डर,
आप हमको रीजन ऑर्डर, आप हमको अपने पिटीशन से लिखें, एफिडेविट से लिखें, क्या लिखे हैं? There is encroachment, no encroachment. What do you want to say?
in para number 8 we have stated that in terms of the order of this honorable court, the circle officer Hydernagar in presence of the petitioner and other villagers have done the spot verification of land number such and such and submitted a report whereby it has been stated that the nature of the land in question is Gair Majura Aam type and the land has been mentioned as Kabristan. And in light of that, the reason order has been passed, that is in
But ये next page पर.
That it is most strongly stated and submitted that the answering opposite party number 2, after considering every aspect of the case, has also passed a reason order by letter number such and such, whereby the claim of the petitioner has been rejected as baseless.
Now you tell us, from where do you read that the nature of land in question is Garmajuba Aam and type of the land is Kabristan?
From the inspection report, reason order says so.
Reason order in the inspection report. Reason orders is based on inspection report. Read it from the inspection. This is khata number. What is the plot number? Khata number 120. Plot number 126.
In order to clarify that if I may be permitted to file a supplementary show cause, if that is the issue.
Fine.
I'm fine.
Learned counsel for the parties are present. Counsel for the opposite party prays for time to file a supplementary show cause in the present case. Let the supplementary show cause be filed by (29th October). 29th of October. Post on 12th of November with supplementary.
Item 43, contempt civil 393 of 2024.
Sorry?
The order may be uploaded so that it may be sent.
Yes, yes. It will be up.
Since the petitioner has to appear on
Yes, yes. Those matters where I am giving direction for appearance on Monday, the order will be uploaded. They are conscious of this. आप लोग सैटरडे को छुट्टी मनाते हैं, हम लोग नहीं मनाते, यहीं पे रहते 10 बजे से लेकर 5 बजे. You can see me in my chamber here. Okay. I will be here only, don't worry. I will ensure that all the orders, कुछ फाइनल जजमेंट्स ऑर्डर में टाइम लगता है थोड़ा सा, जो अर्जेंट होते हैं वी ट्राई की वो आप लोग.
इसमें एक आईए फाइल किए हैं वो स्टैंड के लिए, लास्ट चांस एक बार दे दिया है.
जस्ट रीजन ऑर्डर पास करना है डीसी को।
4 वीक हर टाइम चाहिए। कब फाइल किए हैं आप? 4/10 को। 4 वीक कब आपका एक्सपायर कर रहा है? भाई 4/10 को 4 नवंबर को, ठीक है। तो हम आपको ये डेट दे देते हैं 12 नवंबर को, 10 तारीख तक फाइल कर दीजिए। The learned counsel for the parties are present. Counsel for the respondent state has submitted that IA number 11289 of 24 has been filed seeking 4 weeks time to file a compliance report. To file a compliance report. The IA has been filed on by affidavit dated 4/10/20. Posed this case on 12th of November 24. Let the compliance report be filed by 11th of November 24. IA number such and such is closed.
Item 44, contempt civil 431 of 2024.
In this case, we are ready to file also.
What is your assurance?
Order has come transit.
Order has been complied?
Not at all.
Not
But reason order has been passed. Already.
My lord, in the last occasion, I have submitted that honorable court that they have issued a new cause of action and it has been rejected by saying that the post is not sanctioned. On the read court, well, the whole read court has been done and the honorable court has passed an order. Nowhere not a single sentence has been submitted by the respondent, my lord, that saying post is not sanctioned. Now, my lord, after the passing the order of the honorable court, now they are taking a new cause of action. The post is not sanctioned. That's why the sick pay revision and the salary will not be given. And they rely upon the honorable court has relied upon my lord, the read court order 462 and LPA. It has not been even dealt in the whole read court. They have not even a whisper of that.
You see, the writ order was passed without calling for a complaint.
And supplementary counter affidavit has been filed by the university. They have not given that submitted, my lord. The post is not sanctioned on that time, my lord. They should have been, my lord.
No, you see, Annexure 1 dated 16/5/23. Para number 5 has that supplementary counter affidavit has been filed. You see, the university sends the letter to the state. Right? Now the state would see whether there is a sanction post or not, and it is the decision of the state. Did the state file any counter affidavit? Did the state file? State did not file any counter affidavit. Then it is certainly open to them to see whether the post is sanctioned, not sanctioned, merely because university will forward. That does not mean that you will get the relief. State has to act as per the norms. Unless the post is sanctioned, under what date they will release the money. So if there is no sanctioned post as per them, that is certainly a fresh cause of action. Then you can say that they have taken the work from you for so many years. We do not know, there are numerous judgments on that. So that is a separate cause of action. Then in the writ petition, we are not calling for a counter affidavit and we are just asking them to take a decision. Every aspect of the matter is open to them, including the point of sanction. Had they filed a counter affidavit, then the matter would have been different. No counter affidavit was filed by the state.
The supplementary affidavit will be filed by the university.
University is not state. Money has to come from the state. So we have a fresh cause of action, but content would not lie. Still, if you want to linger, that's your problem.
Just I'm submitting before the court that it is a completely new cause of action. It has not been released on the time the report was discussing.
Contempt Civil 431 of 2024. Counsel for the parties are present. Counsel for the state has submitted that a reason order has been passed.
Yes.
The learned counsel for the petitioner submits that stand has been taken by the state in the reasoned order that the post is not sanctioned. Council, to this council further state submits that at the time of disposal of the petition, no counter affidavit was called for from the state, and therefore the state has acted as per norms. If the petitioner has any grievance, he may challenge the reasoned order. Considering the submission and this court finds that the reasoned order having been passed is not in dispute, but the petitioner is aggrieved by the reasoned order, but no relief can be granted to the petitioner in this contempt proceedings. However, the petitioner may challenge the reasoned order in accordance with this contempt proceeding is accordingly.
So cause may be
A show cause is taken on them. Show cause filed by the state is taken on them. यही लिखे हैं ना sanction?
Yes.
तो कोना में बैठ गए, कुछ बोले भी नहीं, इसीलिए तो सैंक्शन नहीं हुआ आपके प्रोफेसर का, प्रोफेसर है बात बताइए, लीडर का आप सैंक्शन नहीं करके इतना साल काम करा लिए।
काम कराने के बाद नहीं, ये लोग काम कर लेते हैं, यूनिवर्सिटी को खबर नहीं होता, इसीलिए बोल रहा है ना।
He has been transferred, legally he has been transferred from Gilead to here, my lord, in 2004, and 2004 to 2008 he was working as a reader.
You need to fight it out.
Well, much better.
Item 45, contempt civil 449 of 2024.
Lordship, the order has not been complied with. The show cause has been filed, Lordship. I'll take just 5 minutes to demonstrate my case, Lordship.
Why order has not been complied?
According to us, my lord, the order has been complied with. My lord, kindly see the impugn order, my lord, page 16, my lord, the operating power.
Lordship, may I be just allowed initial 5 minutes to make my case?
जब हम respondent को पूछ रहे इसका मतलब हम satisfied हैं कि order complied, let them satisfied. हाँ बोल.
My lord, look, kindly see page 16.
हाँ. Yes.
In the aforesaid para 16, in the aforesaid facts and circumstances, the point regarding jurisdiction can certainly be raised before the respondent, even at this stage. Therefore, while not deciding the issue of jurisdiction, under Article 226 upon of the Constitution of India, at this stage of the proceeding, it is left open to the petitioner to raise the point of jurisdiction along with the supporting circulars rules which the petitioner may rely upon before the inquiry officer and also the disciplinary authority within a period of 3 weeks from today.
Did they raise
Upon
the
raising such issue, the concerned authority shall pass an order on the point of jurisdiction also while passing the final order in the disciplinary proceeding. The matter has remained pending by virtue of the interim orders passed by this court, and accordingly the respondents are directed to expedite the proceedings and conclude the same, preferably within a period of 4 months from the date of communication of this order. At this stage, the learned counsel of the petitioner submits that the petitioner has also raised a grievance with regard to the non-furnishing of certain documents he has submitted, that the list of documents has been furnished, but the annexes to the list has not been given to the petitioner. In view of the aforesaid submission, at this stage it is observed that if the petitioner has not been given the required document, the same will also be furnished to the petitioner within a period of 15 days. So, we are taking
दो चीज था, documents देना था,
Yes.
है ना? दूसरा अगर jurisdiction का कोई point है उसको भी decide करना.
Lordship.
You have done both of them.
Lordship. Whereas the final order with respect to the disciplinary proceeding has been passed, my lord. The reason order is at page 57 of the
57 of the show cause.
Sukkot.
कितना लंबा reason order pass हुआ? 57. Where is the point of jurisdiction?
And yes,
Did you get the documents or you did not get them?
I did not get it, Lordship.
The documents were not.
No. I had applied for 112 pages of the document, we just supplied 4 pages. And that was my specific government, both in the writ petition, in the representation which I made, and even till date.
but in paragraph 7 I have stated so. Page 9 of my Sukkot.
Lordship, in the reason order, point of clarification.
Yes, yes. Yes, please.
Well, para 7 in the middle. Further, as regards the furnishing the list of documents required.
Para 7 of page?
Page 9 of the SOCO.
Page 9. Yes.
Further, as regards the furnishing the list of documents required to the petitioner, it is stated that in compliance of the order it so and so the copy of the inquiry report containing only 4 pages was submitted by the inspector to the senior divisional security commissioner. Dhanbad, ECR Dhanbad has been sent to the petitioner by Ritna number so and so so and so. However, same has already been given to him earlier, but the petitioner always demanding the enclosures that has been annexed by the IPF battalion so on. Regarding that, it is pertinent to mention here that it is not desirable to hand over CDR report being confidential and statement for non-railway person is safety point of view, as the report of the CDR has to be taken from the office of Superintendent of Police confidentiality and to save the life of the person concerned. In RPF, Goma number, register number so and so, an inquiry was conducted by the inquiry officer inspector RPF post and its report dated 17/2/2023 submitted to Senior Divisional Security Commissioner wherein the petitioner Sanjit Kumar was an accused. In connection with the inquiry report dated so and so, Senior Divisional Security Commissioner instituted a preliminary inquiry against petitioner Sanjit Kumar on the basis of the preliminary inquiry report dated so and so. Its connection, disciplinary authority cum Assistant Security Commissioner Dhanbad issued a major penalty charge sheet memorandum dated 26/5/23 against the petitioner, in which CDR is not mentioned.
Yes, I get it, but so there is a legal impediment in supplying the
Those
documents
documents.
that he is demanding.
Confidentiality was the reason.
Then under such circumstances, you could have filed a petition for modification of our order.
This fellow that could
That
have
is the
been.
only way. Otherwise, as order is standing, isn't it?
Lordship, they should also explain regarding the point of jurisdiction.
Want of jurisdiction has been decided
From the reasoned order, Lordship.
in the reasoned order. Show it from the reasoned order.
Reason order में है.
It is not there, Lordship. I have read the entire 16 pages of the reasoned
क्या
order.
है कि उसको करते हैं? जो आपको बिल फाइल करें, स्टेटमेंट से ये ऑफ कंप्लायंस होगा. Lord, I will file supplementary.
जो भी है, अगर मान लीजिए आपको लग रहा है कि कुछ एरर रह गया है,
Then I'll rectify.
you rectify, pass a fresh order.
Yes, Lord, I'll rectify.
ठीक है, इसमें तो कोई दिक्कत नहीं है, लेकिन ये कॉन्फिडेंशियल डॉक्यूमेंट देने में दिक्कत है.
The steps which is required to be taken, Lord, I'll take it.
Lordship, just one submission. Lordship, the charge against me was that on the date of duty, I did not sign the register and was present at some other place. Now, Lordship, this entire charge does not. Now they have written that there is threat to life of the person. I am okay with if the CDR report is not furnished, but apart from that, there are witness statements, Lordship. And the reason which they have assigned in the show cause is that there is threat to the life, and in order to save them. Lordship,
I will inquire.
it is
I will
not-
try and inquire, Lord, so far as that
You
part.
find it out. If
I'll-
required, you file a modification.
Yes,
in
Lord,
the
I'll take the
petition,
necessary
and then we
steps.
will see what order can be passed, because as per the norms, there are certain, they have a right to withhold certain things. They have a right, right?
Yes, yes.
So
My
I'll
only
simply
point
sit
was
and
that
adjourn it.
they could have said it in the reason order why they are not doing. All these things have been brought on in the show cause amendment, Lordship, not in the reason order.
आप देख लीजिए, थोड़ा देख लीजिए.
I'll see.
Learned counsel for the parties are present, appearance. The counsel for the opposite party seeks adjournment. Post on 13 December.
Yes, by that time.
आप इसको रेक्टिफाई करिए.
I will.
और इनको अगर मान लीजिए फ्रेश बुलाने की जरूरत है, देखिए दो
Whatever,
तीन चीजें.
before,
एक तो
there are two things, which I have inferred. First, so far as the documents are concerned, we will have to file a CMP application for modification of the order.
If
So
you
far as
think
that part
so,
is
there is
concerned.
another way of doing it. Copy आप उनको ना भी दें, inspection दे सकते हैं.
Yes, my lord, if at all that can be permitted.
If that can be permitted.
Yes, my lord, that
अगर
I'll
मान
see.
लीजिए आपके पास 112 documents है.
For that also, my
कुछ
lord, I'll have to
documents-
file a CMP
that's
application.
it. For कुछ documents हो सकता है कि उसमें कुछ ही ऐसे documents है जो confidential हो. सारा
Yes.
attendance register जैसा चीज है.
बहुत सारा चीज होगा.
बहुत सारा चीज होगा.
नहीं, वो
थोड़ा
बहुत casually proceed हुआ.
आप उसको देखिए. इनका भाई जो भी है.
I'll see to it. I'll see.
और jurisdiction वाला point आप अपना देखिए.
I'll see.
Item 46, contempt civil 453 of 2024.
Order is not been complied with. The operative part is at page 11, para 9, the directive part.
Petitioner is coming for the first time. I was paying some time to file this report.
One submission, my lords, your ladyship had directed them to conduct a medical board for the petitioner. My lords, he is 100% blind. It has been 6 months since he made representation. Till date, the medical board has not been constituted.
थोड़ा भी नहीं.
Bishop, I will seek instruction what has happened in this case. Because it is 6 months. However, delay was on their part also.
अब ब्लाइंड लोगों के पीछे आप डिले क्यों नहीं?
नहीं, she was done previously.
ब्लाइंड पर्सन का एप्लीकेशन ऐसे फाइल नहीं है. आगे से ध्यान रखें. ब्लाइंड पर्सन का उनके नेक्स्ट फ्रेंड से, उनके बेटा से, किसी से भी आप एप्लीकेशन राइट ऑन हिज इंस्ट्रक्शंस यू आर फाइलिंग व्हाटएवर.
Keep it in mind.
आगे से लेकिन इसका तो कंप्लायंस होना ही है कंटेंट, लेकिन दिस को cause some trouble at any point of time.
Yes, please. I get
The learned counsel for the parties are present. Counsel for the petitioner submits that the petitioner is completely blind, and by virtue of the order passed by this court, a medical board was to be constituted, but the same having not been constituted, the present petition has been filed. The present petition has been filed. Counsel for the opposite party. You will accept notice on behalf of Mr. Navneet Kumar.
Yes,
Mr. Soesto नाम इनका नाम दें. Mr. Ekedas. Mr. इनका आप अपना नाम बताएंगे.
Sahai Gaurav.
Mr. Sahai Gaurav. Piyush. Junior associate counsel to Mr. Ekedas submits that Mr. Das would accept notice on behalf of opposite party number 2, Mr. Navneet Kumar. He prays for time to file a show cause in the matter. He submits that if the order has not been complied so far, the same will be complied if there is no legal impediment, and compliance report will be filed. Post on next Friday.
Bishop, some Bishop 2 weeks.
नहीं.
Not more than that.
Blind आदमी का एक एक दिन important है. Better be sensitive to them. I am posting it on 28.
Monday.
28th October. आज 18th है ना? Next Friday will be 25th. 29th October in the supplementary course. Constitute करके इनको बुलाकर, फोन नंबर है आपका, आपके क्लाइंट का, इनको दे दीजिए. ठीक है? करके इसको compliance करो.
Item 47, contempt civil 479 of 2024.
Order is not been
Has been complied, Your Lordship.
There was
उनको दे दिया.
उनको दे दिए Lordship.
फिर क्या है?
This may be brought on record election because
Brought on record Lordship, it is नापी करने का ऑर्डर था Lordship. factory, Tala factory का नपैया का matter था, that has been done, your lordship.
In presence of petitioner,
In
the
presence of
demarcation was supposed to be done, your ladyship, and that has not been done.
Number of times, your lordship, arm istihar has been issued, your lordship. The petitioner chose not to appear, your lordship. There were several times
ये तो
objection.
डेट भी फिक्स कर दिए यहाँ से, फिर क्या किया?
Petitioner was present, your ladyship. I have annexed the representation also.
That is
The
representation is not your
Annexure
presence.
2 and Annexure 3 to the contempt application, which I have annexed.
Lordship, you see the order, lordship, and the map also is there, your lordship.
This document will be brought on record because last time also there was direction that the show cause may be filed so that I can take instruction from the client to division.
Where have you stated that you were present on 27/6/23?
I filed representation.
Where have you stated that you were physically present on 27/6/23 in terms of the order of this court?
On 30/6/2023.
On 27/6/23. You see, the petitioner or this authorized representative to appear before the respondent deputy commissioner on 27/6/23. What is your statement with regard to 27/6/23?
Your ladyship, there after that date, your ladyship, I was present, and Annexure 2 and Annexure 3 may be seen, your ladyship. I have submitted. I have applied for the certified copy of the order dated such and such, which has not been made available to me till date. But the web copy of the order was uploaded on the website, and the same has been made available to me in the evening of 28/6/2023. I am reading Annexure 2, page
This you
11.
filed your representation. It has been received on 1/7. Right? You have filed it on 1/7.
On 30/6/2023.
No, that is the date at the bottom, 1/7.
It was received because in the evening 28/6/2023 I received the order at 8 p.m.
On
Yes.
21/6/23, you had applied for certified copy, and on 24/6/23, the requisites were notified. If you sleep over it, that's your problem. The order was passed in open court.
I submitted my representation.
दिखाइए. Sure.
Anyway, lordship, the
नहीं वो आप जरा इनको. ओपन कोर्ट में ऑर्डर होता है ना? एक एक प्रोसीडिंग हम लोग का वीडियो में अवेलेबल है, फिर क्या सोचना है? और आप जरा देखिए आपका, यू जस्ट सी when you make a statement, order not uploaded, not got, you just see when did you apply it, when was it notified, and what were you doing.
After it was uploaded, the petitioner.
You just, it was ready on 24th. Ready कैसे हो जाएगा अगर upload नहीं होगा तो? You must know the procedure. Ready होता ही नहीं है, कुछ notify होता ही नहीं है जब तक upload नहीं होगा order, है ना?
Let me take instruction from my client. Let it be taken up in the next week. I take instruction. And by the time that order will be
Submit कहाँ है? देखिए कब upload हो जाएगा.
डेट 7 महीने खत्म हो गया.
वो तो दिख ही रहा है, उसी में ही दिख रहा है. The learned counsel for the parties are present. The learned counsel for the state has submitted that the order passed by this court has been completed.
we have
You filed it. Filed it.
yes, lordship. Lordship, but I'm saying that this may be taken up after the Diwali holidays, lordship. Since the deputy commissioner has to come and sign, lordship.
A copy of letter number 399 dated 24/6/2024 has been produced. A copy of the said letter has been handed over to the petitioner.
Yes.
The learned counsel for
Today only it has been handed.
the इतना ही काफी है, ज्यादा कुछ बोलने की जरूरत नहीं. Demarcation किए कि नहीं किए?
No
Yes.
election.
Map is there, lordship.
Map के
By
साथ
this order also, your ladyship, which has been handed over to me, by this also it is not specific that demarcation has been done. Only instructions has been given and a direction was that in presence of the petitioner the demarcation was supposed to be done.
तो आपको तो 27 तारीख को अपीयर होना था ना, यहाँ से कोर्ट से डेट फिक्स कर देते हैं, टाइम फिक्स कर देते हैं, वीडियो में सारा रिकॉर्डिंग करके अपलोड कर देते हैं यूट्यूब में, और आपके लिए हम क्या कर सकते हैं बताइए? नहीं, व्हाट एल्स कैन कोर्ट डू फॉर यू? आपके घर पहुंच जाए हम लोग, गाड़ी भेज दें आपको लेने के लिए, क्या करें हम लोग आपके लिए? आपके प्रेजेंस में ऑर्डर करते हैं, फिर भी आप लोग ऐसा करते हैं।
I take instruction.
And even if suppose there is an order not uploaded, it is there in the public domain. You can still go कि भाई order हम बाद में produce करेंगे, लेकिन हमको direction था आज appear होने के लिए, हम appear हुए। Possible है ना? Post on next Friday.
Next Friday.
खाली उनको she has to seek instructions. The counsel
By
for
that
the
time, I'll try
petitioner.
to file a short.
The counsel for the petitioner seeks adjournment. Post on next Friday. देखिए, इससे ज़्यादा हम आप लोग के लिए कर नहीं सकते, इससे ज़्यादा ट्रांसपेरेंसी हम आपके लिए नहीं कर सकते। I can't do anything more than what I'm trying my best. हाँ, ऑर्डर अपलोड होने में टाइम लगता है, करेक्शन में टाइम लगता है, एरर हो जाता है तो दिक्कत है, बट इज देयर, इट्स अ पार्ट ऑफ आवर सिस्टम। आप भी तुरंत प्रोनाउंस करके आप सोचेंगे कि शाम तक अपलोड हो जाए, आपका क्लाइंट आता है तो 1 महीना बाद रिट पिटीशन फाइल करें।
By the time they may file show cause.
नहीं, आप पहले अपना इंस्ट्रक्शन लीजिए, क्योंकि आप बहुत स्ट्रॉन्ग स्टेटमेंट दिए, पहले आप अपना इंस्ट्रक्शन लीजिए।
Item 49, contempt bill 504 of 2024.
Lordship, in this case, compliance report has to be filed. They have
It is
not
in the
filed.
process, Ladyship. We had preferred an LPA, time has been extended, and
LPA has been
LPA was dismissed, but the time for compliance has been extended till 28th October.
Did you file your compliance report?
Ladyship, it will be 2 weeks.
Jharkhand compliant report file करने का order हुआ।
पहले कंप्लायंस रिपोर्ट फाइल कर देते हैं, फिर वी विल बुक देम फॉर द डिले।
Ladyship, in LPA the time was extended.
Contempt civil 504 of 2020. Also for the parties are present. Counsel for the opposite party prays for time to file a compliance report. At his request, the matter is directed to be posted on 14th of November in supplementary cause list. The compliance report should be filed by 12th of
Item 50, contempt civil 540 of 2024.
For withdrawal, Ladyship. On instruction of the client.
contempt civil order has been complied or set aside.
Ladyship, I have just been instructed to withdraw.
कोई प्रेशर तो नहीं है?
नहीं, Ladyship, कोई pressure नहीं।
Contempt civil 540 of 2020. Counsel for the parties are present. Counsel for the petitioner on instruction seeks permission to withdraw this petition. He submits that the petitioner, that is all. Counsel for the state has no objection to the prayer for withdrawal. Since the petitioner is not interested in pursuing this contempt application, on instruction, contempt application, this contempt is hereby dropped.
Right.
Item 51, CMP 581 of 2024.
Yes, madam. What happened?
As on order 27 February 2024, court ordered the petitioner to remove for the removal of defect within 21/3/2024. But due to inamendments, we couldn't do so.
Why didn't you do so?
For removal of defect.
Why didn't you remove the defect? Sorry?
That I was not aware.
Para 5 पढ़ लीजिए. Restoration में कोई दिक्कत है?
That you will pay
It's your first appearance? No.
in this court.
Yes.
Yes.
How long have you been practicing?
Since 6 months.
Petition पढ़ लेना चाहिए. Para 5 में दिया आपको. ठीक है? देखिए CMP number 581 of 2020. What's your name? Bharti. Counsel for the petitioner. This petition has been filed for restoration of WPS number 2866 of 2023, which to dismiss for non-compliance of order dated 27/2/2023. Counsel for the petitioner submits that due to inadvertence, the defects could not be removed. She submits that the writ petition be restored and time for the time for removal of defects be extended. The learned counsel for the state has no objection to the prayer for restoration, considering the submissions. The order dated 27/2/2024 so far as considering the submissions, the petition being WPS number 2866 of 2023 is restored to its original file. Office is directed to place the petition before appropriate bench as per listed.
Item 52, contempt 593 of 2022.
My lord, kindly see my lord's last order. In spite of my lord's last order, my lord, there is no compliance.
Yes. Why have you not complied the order?
Not all the bank details of mine, my lord, were recorded in my lord's last
Yes.
order, my lord, in spite of that.
क्या बात है?
Kindly see annexure D, lordship, page 24. Partially direction to the given Upayukta Urvi Shivam Jamshedpur Dhunbad lordship.
तब क्या करें? आपको बैंक डिटेल दिए हुए क्यों नहीं पैसा जमा कराएं? Order has been set aside, modified by any court. No. Yes, you tell us. Every day post कर देंगे केस.
Your Lordship, there were
Saturday, Sunday को.
Yes, Your Lordship, there were two cases in which bank details was provided, Your Lordship. In one case, we have deposited the money. In one case, we have failed to deposit, Your Lordship, because just now I have received the oral instruction, Your Lordship. I said that the DPO was not well and he was on leave, so 1 week time. In one, we have complied, Your Lordship. Serial 67.
Contempt case civil number 593 of 2020. The learned counsel for the parties are present. Counsel for the state has submitted that as the district transport officer of as the concerned district office transport officer was not well, the order dated, the amount could not be remitted to the account of the petitioner. He prays for 1 week time. Post on 25th October. The compliance report be filed by 24th.
There was a personal appearance.
But you never said. Nobody mentioned it.
Nobody had mentioned because I thought that the case would be taken up.
Why did you think so? यहाँ पे तो कभी-कभी item number 2 भी नहीं take up होता.
यार ये केस बहुत लंबा चल गया. So actually the matter was with regard to there were certain properties. The CO बढ़ गए.
इनका सारा केस कंटेंट में आते रहता है. इनको तो एक रूम दिला दीजिए झारखंड परमानेंट स्टे.
अब यहाँ हुआ क्या है?
कोई ऑर्डर कंप्लाई नहीं.
नहीं ऑर्डर जो है वो ऑर्डर ये है कि SAR केस का ऑर्डर को माने फाइनलिटी हो गया, दैट हैज टू बी एग्जीक्यूटेड।
हाँ तो क्या हुआ, एग्जीक्यूशन क्यों नहीं कर रहे? अब क्या प्रॉब्लम है?
प्रॉब्लम कुछ नहीं है, मानो टाइम चाहिए थोड़ा और।
टाइम तो आपको पिछली बार दिए थे ना
हाँ
किसी
टाइम
केस में।
मिला था बट
क्या स्टेप आप लिए? टाइम लेने के बाद आप क्या किए? व्हाट हैव यू डन? आपने क्या किया टाइम लेने के बाद?
जिस आदमी को वहाँ से रेंटल के रूप में अमाउंट को निकाल दिया गया है, सिर्फ एक जो मकान मालिक है वही नहीं निकल पाया, समय की मांग कर रहे हैं और उसके पति हमेशा बैग रखते हैं, महिलाएं तो रहती है जो
आप लीजिए आप कौन हैं इस केस में?
हम है जो रिस्पोंडेंट नंबर 6 रिट पिटीशन जिसके अगेंस्ट में ये ऑर्डर है which is going to be implemented.
हाँ।
They are present in the court में।
हमको देखना नहीं किसी को।
नहीं हमारा सिर्फ इतना करना है।
कितना टाइम चाहिए आपको खाली करने के लिए? खुद खाली करेंगे कि आपको खाली करवाएं?
नहीं हम तो बोल रहे हैं जो कि हम खाली कर देंगे बट बिफोर दैट खाली हम 1-2 पिटीशन फाइल करेंगे, हम खाली कर रहे हैं कि 15 तारीख को लगा दिया जाए। अगर मेरा पिटीशन
कौन से 15 तारीख को लगा देंगे?
नवंबर
15 नवंबर दिवाली का ये लोग बाहर बिताएंगे रोड पर?
नहीं इनका भी घर है, ये सारा एक ही फैमिली का मैटर है। एक ही फैमिली का मैटर लैंड डिस्प्यूट में SAR केस चला दिए जिस कोर्ट का कोई जुरिस्डिक्शन नहीं था। एक सूट फाइल हुआ था, इनका हाई कोर्ट में हजूर वकील रखे थे लेकिन इनका केस को प्रॉपर्ली प्रेजेंट नहीं किया गया और उसके चलते हजूर इनका जो सारा डॉक्यूमेंट है कोई काउंटर एफिडेविट भी फाइल नहीं हुआ एंड दिस ऑर्डर हैज बीन पास।
ऑर्डर आपने चैलेंज नहीं किया?
हजूर फॉर द फर्स्ट टाइम जब ये सर्कल ऑफिसर साहब स्पॉट पर पहुंचे देन ओनली दे केम टू नो दैट
उससे पहले इनको पता ही नहीं था।
नीचे
बात बताइए SAR कोर्ट का ऑर्डर इनके अगेंस्ट में हुआ था कि नहीं हुआ?
हाँ SAR कोर्ट का ऑर्डर इनके अगेंस्ट में
जो फाइनल हो गया था कि नहीं हुआ?
नहीं उसके अगेंस्ट में जो सूट फाइल किया वो सूट में उसी ऑर्डर
अगेंस्ट SAR कोर्ट के ऑर्डर के अगेंस्ट में सूट फाइल
सूट
होता
हो
है?
सकता है।
कौन सा सूट? कौन प्रोविजन?
वही सारा फैक्ट हम ले आते
कौन
हैं।
सा प्रोविजन में आप SAR कोर्ट के ऑर्डर के अगेंस्ट में सूट फाइल?
सिविल सूट इज मेंटेनेबल मतलब उसका सारा हम जजमेंट दिखा देंगे।
सूट आपने फाइल कर दिया?
सूट फाइल कर दिया, दैट सूट इज पेंडिंग। उसके बाद हजूर ये लोग आए
इंजंक्शन मिल गया आपको?
एक्सटेंशन नहीं मिला, हम कह रहे हैं कि
इंजंक्शन मिल गया आपको?
इंजंक्शन पिटीशन इज पेंडिंग आल्सो। मेरा ये कहना है जो रिट पिटीशन में माय फैक्ट हैज नॉट प्रॉपर्ली बीन प्लेस्ड बिफोर दिस वन।
Who is responsible for that?
Definitely I am well, but considering
What
that they are scheduled tribe minus अभी घर खाली करेंगे हम इतने
scheduled tribe तो पिटिशनर है ना?
एक ही फैमिली है जो इसमें चलना ही नहीं चाहिए था SAR केस। एक फैमिली में 2 शेड्यूल्ड ट्राइब में आपस में फैमिली मेंबर्स में सिविल डिस्प्यूट था। SAR कोर्ट without any jurisdiction interfered and passed the order. Therefore, they went to the civil court for declaration that all these orders were without jurisdiction. तो ये बात था, ये सब
वहाँ पे सिविल कोर्ट इसको डिक्लेयर करेगा विदाउट जुरिस्डिक्शन।
हम
नहीं थोड़ा हम समझने दीजिए।
मेरा खाली इतना कहना है कि अभी चूंकि हम ना तो कोई पिटीशन कल से इनका सारा कागज देखे हैं, अभी हम ना तो कोई पिटीशन फाइल किया बिफोर मैनस।
आपका वकालतनामा है कि नहीं?
वकालतनामा मेरे पास है।
आपने पास रखी है? आपने फाइल भी की है? यू आर नॉन सिटीजन।
आज मिला। Therefore, I am seeking leave of this court. I will file all the proper petition by Monday. उसके बाद हजूर खाली सुनवाई कर लिया जाएगा। If I will
कंटेंट में हम क्या सुनेंगे?
नहीं हम कंटेंट में
हम क्या सुनेंगे?
कंप्लेंट में रिट फाइल करेंगे और जो रिट का ऑर्डर है उसका रिव्यू फाइल करेंगे। अगर हजूर को लगता है कि अगर ये ऑर्डर रिव्यू करने लायक है होगा, नहीं तो हम खाली कर देंगे। हमारा इतना ही प्रेयर है बिफोर माय लॉर्ड कि हमको एक बार सुन लिया जाए, क्योंकि प्रॉपर्ली आई वाज नॉट प्रॉपर्ली अलाउड टू प्लेस माय केस बिफोर माय लॉर्ड। सो आई वांट सिंपली टू फाइल अ रिव्यू पिटीशन। अगर हजूर हम नहीं सकेंगे तो हम अंडरटेक करते हैं, हम खाली कर देंगे। अगर हजूर को परसुएट नहीं कर पाए फॉर रिव्यूइंग द ऑर्डर, आई विल वैकेट द। वैसे इतना दिन हो गया, हम 45 से वहाँ रह रहे हैं 1945 से। एक महीना में किसी का कुछ नहीं बदल रहा है। फेस्टिवल सीजन है, ऐसे भी डेली पानी पड़ रहा है, जो बूढ़ी औरत और बच्चा लोग हैं, जो कि CO साहब भी बोल रहे हैं कि वहाँ ये स्थिति है। हमारा खाली इतना ही प्रेयर है, 1 महीना का हमको समय दिया जाए, हम खाली पिटीशन फाइल करते हैं। हजूर सुन लीजिए, अगर हम कन्विंस नहीं कर पाएंगे।
जब तक आपका वकालतनामा मेरे पास नहीं है, आपके क्लाइंट को हम आइडेंटिफाई नहीं करते हैं, आपने रिकॉर्ड में वकालतनामा नहीं फाइल किया, हम आपका एक भी स्टेटमेंट रिकॉर्ड नहीं करते।
हम नहीं बताएंगे।
तो फिर
therefore I am whatever I am submitting after seeking leave of this room।
नहीं,
हमारे पास
Any person appearing without a वकालतनामा, I don't know. We just can't acknowledge.
इसको ट्यूसडे को आप पोस्ट कर दीजिए, जो हम उसके पहले सारा चीज पिटीशन फाइल कर देंगे।
आपका कोई भी चीज हम नहीं रिकॉर्ड कर सकते।
रिकॉर्ड करने का हमने बोले जरूरी हाजिर, आई एम बीइंग अ लॉयर ऑफिसर ऑफ द कोर्ट, ये मेरा सबमिशन है बिफोर दिस ऑनरेबल कोर्ट कि सिंपल एडजन कर दिया, हम सारा पिटीशन फाइल कर देंगे।
नहीं, he has to file a compliance report. We just do not know. Please, आपको कितना टाइम चाहिए? आपको जो करना है करिए। यहाँ पे ऐसे थोड़ी चलता है। जिस पिटीशन में देवर पार्टीज, we just you have not filed any वकालतनामा, we will not bother to record your.
तो इसमें कंटेम्प्ट में हम पार्टी नहीं आए, जो ना उसके लिए भी हमको पिटीशन फाइल करना होगा, देन ओनली सीकिंग लीव ऑफ दिस ऑनरेबल कोर्ट आई विल बिकम पार्टी इन दिस प्रोसीडिंग। तो फॉर दैट ऑल दैट आई हैव टू फाइल, कल ही आया है जो, तो देयरफॉर दिस इज माय सबमिशन कि 2 दिन का हजूर हमको खाली समय दीजिए, हम तो यही बोल रहे हैं, हम कल सब फाइल कर देंगे ऑल द पिटीशंस।
कब आप सुन पाएंगे? आफ्टर द हाई कोर्ट ऑर्डर?
No, prior to that, वो हाई कोर्ट ऑर्डर में आया है, बट द काउंसिल appearing because he has not filed any counter affidavit, so what was the prayer before the suit? इसके बारे में कुछ नहीं बताया, कह दिया कि सूट में जो है सो दूसरा मैटर के लिए है, जबकि स्पेसिफिक जो है आफ्टर सीकिंग अमेंडमेंट ये सारा ऑर्डर उसमें चलेंगे।
आफ्टर सीकिंग अमेंडमेंट पर
बट इनिशियली शायद करता है, नहीं करते सूट का, तो यही
रीट ऑर्डर के बाद ही किया होगा।
नहीं ना, वो तो हम
नहीं जानते।
रीट के पहले क्या हुआ, वो रीट का ऑर्डर ही देख लिया जाना, उसमें मेंशनिंग है सूट का।
हमको नहीं पता, इतना दिन तक सो रहे हैं, हम तो क्या ही करें।
अगर
क्या करना है पिटीशनर बोलिए। देखिए 4:45 बजे
लास्ट ऑर्डर मैंने 27 ऑर्डर लिख लिया।
4:45 बजे हम कोई ऑर्डर नहीं करेंगे, हम आने दीजिए नेक्स्ट फ्राइडे आएगा, हैज नॉट टेकन अप रहेगा, वी विल नॉट कॉन्सिडर। अब इनका पर्सनल पेरेंट्स आएंगे, फिर काम ही ऐसा करते हैं। आप सुबह 10:30 बजे ना मेंशन किए, ना 2:15 बजे मेंशन किए। एक पब्लिक सर्वेंट को आप पूरा दिन कोर्ट में बैठा के रख दिए। Who will pay for it?
I could have mentioned if you would have
Could
come
have.
at 10:30. अगर ये 10:30 बजे
आप
आ
इंस्ट्रक्शन
जाते
ही नहीं देते हैं 10:30 बजे आने का। बोलना क्या है, आपको इंस्ट्रक्शन देना चाहिए भाई, आप आइए 10:30 बजे केस मेंशन करेंगे, हम आपको रिलीज करेंगे। पिकनिक मनाने आए हैं हाई कोर्ट में, सुबह 10:30 बजे से लेकर 4:45 बजे तक यहाँ बैठे रहेंगे और 4:30 बजे मेंशन करेंगे कि हम आए हुए। और ये पहली बार नहीं है, यहाँ पे हम देख ही रहे हैं कि मेंशन नहीं करते, कोई पर्सनल अपीयरेंस से केस टेकअप कर लीजिए। छुट्टी पर होंगे आज, छुट्टी पर हैं, ड्यूटी पर हैं, और यहाँ क्या किए पूरा दिन, नो वर्क। हम इनका अपीयरेंस भी नहीं रखते, आई जस्ट नो, आई विल रिकॉर्ड नथिंग। 4:45 बजे किसका ही क्या रिकॉर्ड करें। क्या नाम है आपका, नाम बताइए और इनका डिटेल दीजिए। At 4:30, Mr. Rakesh Kumar, Counsel for the State, has mentioned that Mr. So and so Circle Officer such and such has come before this court, is personally present before this court pursuant to order passed in Contempt Civil 698 of 2024. That this matter will be posted on the next slide.